It's time for Friday Night Live. I know. I said this week I'm off. We were not streaming, and I left open a door for wildness. And while I think this is the right ruling, I still categorize it as wildness because the California case where Triller sued Ethan Klein, his company, TED Entertainment, um, Teddy Fresh, the clothing company that's literally not related in any way, and more, um, has been dismissed because Ethan Klein won his anti-slap suit or his anti-slap motion, which is exactly what I thought would happen. I mean, not to like toot toot, but that's because that's just logical. It was a logical motion. There were problems on the face of the complaint. And now there are some things that comes next. So we're going to go through the judge's 19-page ruling. We're going to talk about what comes next from here and what is happening with the two remaining lawsuits, the federal suit over essentially copyright and the defamation suit regarding Ryan Kavanaugh. Just a reminder, the Law Nerd Chat is a special place where, though we talk about subjects, we do not disparage people. And I know sometimes that is difficult when they are people that we don't love. I get it. I get that it's hard, but we're law nerds and we can do two things can be true at once. So that is what we are doing tonight. I will do a quick or a weekly roundup, and that's it. Then we're just talking about this because it is a extra special ride on a Friday because I'm not we were supposed to be off this week, but that's okay. This is worth it. I love the way that the judge broke this down, and I'm excited. I'm excited to go through it with you guys, truly, and to go through the finer points of this lawsuit and what it means for the coming lawsuits. I've seen a lot of questions around the interwebs about it, so we should just get into it. We should just get into it. Let me know where you guys all are coming in from, what you're drinking. I have some peanut butter cup whiskey this evening with some fresh nails. That was courtesy of this week. We've got Fred in the background. George is upstairs with my kiddo. We've got some waters too, because we do both. There's no shade. We do water and whiskey this evening, but it's a whiskey night. It is. It just is. So we'll just get into it. We're just gonna go. Let's just go. Hey there. If we haven't met yet, I'm Emily D. Baker, the badass lawyer and everyone's favorite legal commentator. I'm the host of The Emily Show, and I break down the legal shit behind the news and pop culture stories we all want to talk about. I have been a licensed attorney for over 15 years, but this is not legal advice. I should warn you, I'm a big fan of the cursey words. This channel is where the law nerds unite to talk about facts, not fuckery. We do the things, we say the things, it's all the things. So, it's a Friday night. If you guys are new here, if you are new law nerds, oh my God, my chat just jumped. I was trying to say hi to everybody. If you are new law nerds, go ahead and put a 1 in the chat. It's always nice to say hi to everybody who is just joining me live for the first time, though you may have found me ages ago or just this week or on Twitter. Just go ahead and say hello with your 1 in the chat. I am going to go ahead and pop us in real quick to a weekly roundup. I feel like I should just roll the weekly roundup. I'm sure there are tons of foot soldiers in the chat. I would expect nothing less. You guys are a loyal, dedicated crew. And we are going to talk about that. Oh my God, I love a Moscow Mule. I love a Moscow Mule, Colleen. I do. But it was whiskey. It was a whiskey night. I moved to Tennessee. I drink whiskey now. It's part of my identity. I'm not totally kidding. It's delicious. There's so many options. So we love it. You move and you're like, we moved for a reason. And whiskey might have been one of those reasons. Delicious. We should hit the weekly roundup quickly. Before we do that, though, I'm going to tell you a few things. Housekeeping matters. I have shared about Paw Nerd George. He is doing great. He is as himself. He doesn't seem to be in any pain at all. He is not dealing with his injured paw. He had an injured paw. I think he got it from wrestling with brother. We've trimmed their little nails since so that they don't accidentally scratch one another. They play with each other. They're kittens. They play fight, but I think he just got a little cut on his paw and got him to the vet yesterday. He is all good. He is hanging out with my oldest. My oldest is his human. directly his human. So that is what's going on with him. If you guys are new to me and to my content, you can also find me on social media at the Emily D. Baker on Twitter and Instagram. I forgot to tell Instagram I was going live. Sorry, Instagram. I should probably do that in a minute. Oh well, we'll see. We'll see if we can make that work. I don't know if I can make that work. What else? We also have a Patreon with the members only podcast. My podcast is The Emily Show. There's new episodes out every week on a podcasting app here on the YouTubes. You're welcome to like and subscribe if you like the content here. We are rocketing towards 200K here on the YouTube, and that is fantastic. So we binged, and because we binged, we're just going to share that we binged because it's time to bing. Oh, it binged! Move your head! Ah! Because it did. And from that, we have done all of the housekeeping things, all of the I don't know, yeah, housekeeping. That's the best way to say it. And we only have one topic tonight. So I feel like because I wasn't live on Tuesday, we definitely need to do a quick weekly roundup. Roundup. Here's the weekly roundup. This is going to be the fastest weekly roundup we ever do. Prince Andrew's civil lawsuit is going forward. He lost his titles. He's going to defend it as a private citizen. He has to pay for that shit on his own. Big Nirvana Baby. The media all said the case got dismissed. They left out the rest of that sentence. Case got dismissed with leave to amend the complaint. Big Nirvana Baby amended the complaint. I'm going to go compare the two. I think it'll probably get dismissed down the road for statute of limitations, but leave to amend was granted. So the Big Nirvana Baby lawsuit is speeding right along. If you watched this week's podcast episode, you will know how I feel about Alec Baldwin cooperating with law enforcement. As of today, it is reported that he turned over the cell phone to law enforcement in Suffolk County. So the search warrant will be moving forward to search his phone. So he turned over his phone. He actually did comply with the search warrant. He said he had complied and that statements that he hadn't complied were bullshit, but he hadn't complied. But now he has complied. So yay for doing the thing that you said you had done, but you hadn't done yet. Big thumbs up. So those are kind of the top topics that were top of mind tonight for Weekly Roundup. Those are the three. Those are the big three. There is other stuff I have been tracking, of course. Oh, there's one other one. Cochella is suing. Coachella is trying to stop a publishing house from using Bookchella. So there is a trademark battle heating up over Coachella versus Bookchella. Yep. So that I think I might have to lump that in when we do our intellectual property episode that I've been meaning to do for 100 years and we haven't gotten back to it yet, where we talk about like Taylor Swift and Shake It Off, and we're going to have to talk about Coachella versus Bookchella. We have to talk about those things. So in the world of the legal, that is what has happened. Bookchella. Like, is anybody really confused that Bookchella doesn't like have like drugs and bands and James Charles with his ass hanging out in the desert? Like, is anybody actually confused? Is anyone going to think that Bookchella is related to Coachella? What? I don't think there's confusion. I don't think they're going to be able to prove there's brand confusion. Also, I got a new trick. I learned how to make the lights rotate in the background. I don't know if I love it or if I don't, or if it just keeps changing my white balance on my camera, but we're letting it roll for this evening because I want to see how it plays out. And I'm kind of living for the lights, kind of vibing back there. As we're talking about Coachella, we'll let the lights in the background have their own vibe. So yeah, that's what's going on. I don't know why Coachella's getting salty about Bookchella, but That's sure. Let's argue over people trying to read. I look, I try not to mock intellectual property cases. Intellectual property matters, but sometimes it's just dumb. So I've that's me being snarky. I have not read the suit yet. So Bookchella suing over Coachella. Coachella, the music festival, suing over Bookchella. Anyway, shall we just get into this ruling? Should we do a quick road so far? I feel like a road so far is needed. Y'all trying to make me sing early tonight. Ella, Ella, A. Yes, y'all trying to make me sing tonight. It's early. It's early. We haven't had near, well, we sing without whiskey, don't we? All right, let us do the briefest of brief road so fars. Read all of the delicious judicialness of it all. We're going to do a full breakdown. I thought this was a very well-written ruling. I appreciated it. I enjoyed this ruling. This is not my first take. I wanted to read it first so that I could bring more insight than just making fun of some of the things in it, because that's you're here because I've been a lawyer for 15 years, except for that one dude on Twitter who's like, I can't take you seriously because you have purple hair, and then he spelled purple wrong, and I was like, I'm I've been educated as a lawyer for so long that I don't know if it's worth it to fight with you on Twitter. Like, it's just not worth my energy, because no. Like, okay, don't take me seriously. I have purple hair. Bye. Spell purple right. It's not spelled with an I. It's not purple. Anyway, as I tangent right along, let us talk about a quick road so far of the trilleriness of it all. Triller, what the fuck? Triller has filed a plethora of lawsuits against Ethan Klein, TED Entertainment, his company that, takes the 5% and produces the podcasts on the H3 channel. And Ethan Klein as an individual, Ela Klein as an individual, Teddy Fresh Clothing, and others. Triller originally sued in federal court. Triller sued everyone from Mike to the H3 podcast in that suit. The federal judge, who we stan, Judge Anderson, said, WTF, get out. You can't join all these defendants together. This is awful, and we cannot with you. Yeet. So that lawsuit was dismissed as to everyone except the first named defendant, and that has since been dismissed for failure to prosecute. It looks like they didn't find where that company that streamed the Ben Askren Paul fight was located out of and could never serve them. They could bring that lawsuit later if they find that company, but it was dismissed for failure to prosecute. So that's lawsuit number one. I count that first step as lawsuit number one, because they did file 2 amended complaints against Ethan and his companies in those lawsuits. So I count that as lawsuit number one. Then they refiled in federal court just against Ethan and his company. Lawsuit number 2. That is over the fair use or not fair use of it all of the Ben Askren Jake Paul fight. So that is the copyright case in federal court. It's still ongoing. Then Triller sued TED Entertainment, Ethan Klein, and then later in their FAQ, their first amended complaint, Ela Klein, Teddy Fresh, etc., in California, in Los Angeles County, for tortious interference, essentially intentional interference with existing economic relationships, intentional interference with prospective economic relationships, negligent interference with existing economic relationships, negligent interference with prospective economic relationships, and a violation of the California Business and Professions Code 17200. So all of those are kind of predicated on an underlying offense, the underlying offense being defamation and incitement over shit that hurt somebody's feelings that was said on Reddit and in App Store reviews. Yo, Triller, Your shit might be flipped. That. That is what that suit over. That's the lawsuit that has a whole bunch of Reddit comments in it. Again, when you're asking yourself, wait a second, can a creator be sued over things that their fans say on Reddit? Just go, wait, no, that doesn't make sense to me. And you are correct. Then, as I, this is speculative. This is not fact. This is speculative. The timing is sus. As it became clear in the oral motion hearing that the judge was leaning towards yeeting this entire case on an anti-slap, and we'll talk about slap motions in a sec. Then Ryan Kavanaugh was like, speculation. I think it's time for me to file a defamation case. I wonder if Ryan Kavanaugh saw that they were likely going to lose this case and still wanted to sue Ethan Klein for shit Ethan said, and was like, okay, fine then. I'll sue on my own, not under Triller. I'll sue me as an individual, suing Ethan as an individual for defamation. That's the lawsuit that was filed last. And that's the lawsuit that has everything from Trisha Paytas to Keemstar mentioned in it, saying that Ethan Klein is essentially mean for having someone on the podcast that pretended to be Keem's girlfriend that said that Keem cried after sex and had a small penis. Like, that's in that lawsuit. So that's the third lawsuit. If you would like my whiskey enabled breakdown of that lawsuit, it's on all of my Trillery playlists because the Trilleriness of it all is great. So with that, we are talking about the case in the middle, Triller suing Ethan and the companies over App Store reviews and mean shit that was said on Reddit by other people. Can you sue someone for speech of others? That's not how the First Amendment works. So, after that lawsuit was filed, California has a very strong anti-SLAPP lawsuit. SLAPP lawsuits are, SLAPP is an acronym for Strategic Litigation Against Public Participation, literally trying to shut the fuck up, using the court system to try to get someone to stop speaking, using litigation as a strategic way to shut down journalists, to shut down people exercising criticism of the government or others, public figures, Ryan Kavanaugh, Triller, and using their voice or another petition to participate in the public. Not every state has an anti-SLAPP statute. There are some that believe that the anti-SLAPP statutes really don't support the First Amendment in the proper way because they don't allow cases to go to discovery. You have to have a very strong case on its face to survive an anti-SLAPP over speech in California. Before I was a district attorney in LA County, I was a research attorney for civil judges. So I worked at the courthouse where the Britney Spears cases have been ongoing in Stanley Mosque. And a lot of what I dealt with were anti-SLAPP motions. It's a lot of what I read. It's a lot of the work that I did because this is so common that people are like, you can't say that. And people are like, actually, that's not how any of this works. I can say things. Speech is very broadly protected. Defamation is not. So defamation's not protected speech. Opinions are generally not defamation. Being mean is generally not defamation. So the judge granted the anti-SLAPP motion that was made saying Ethan's lawyers, and when I say Ethan says, I need to clarify because generally in this context, I mean, Ethan says through his lawyers. If I'm talking about something Ethan has said on social media, I will clarify where he said it. I'm generally referring to through the lawyers in the court filings. If it's for Twitter or something, I mean, Ethan speaking as himself. Generally, I mean through lawyers. So Ethan's side argued this is protected First Amendment speech about a public figure in a public forum. Thanks for playing. Try again. Out. The court has agreed, granted the anti-SLAPP motion, which means the lawsuit is dead in the water. We have also talked about this in the context of Keemstar because he also won an anti-SLAPP motion against Romeo Lacoste. And as part of his attorney fees, he took less attorney fees, took the play button from Romeo Lacoste, took a Sharpie to it, lined out Romeo Lacoste's name and put his name on the gold million sub play button. Because when you win an anti-slap, you are entitled to attorney's fees. So when we get to what comes next, we will talk about the process for that. Because though the case is done, Triller can no longer sue Ethan Klein over these causes of action. The next step is Ethan Klein going after Triller for attorney's fees. And that will be glorious. So let us just pull this up, and you will see that you're like, we know Emily's read it when it's highlighted in the colors. Yes. Yes, it is. So this is the judge's ruling. This is the Honorable Helen Zirkin. This is out of I believe it's the Beverly Hills. Yes, the Beverly Hills Courthouse in Los Angeles, Department 207. That is where the original OG Toddy Westbrook case was in that, the Beverly Hills Courthouse. Let's see if I can. Did I already do this wrong? Yes, if we make it big this way. And I will say before we get into this, don't forget to like and subscribe. Don't forget to do the things. I will say, EHC Bunny, when we get to questions, you're welcome to bring this one up again. I've been talking about it on Twitter, and I will cover the Cardi B Tasha K suit more next week because they are actually in trial over that. So yes, I will. I think it's a lot. I think there's a lot to be learned from both suits. And I'm always fascinated by following lawsuits that affect the creator sphere and the First Amendment. I think people forget that the First Amendment can protect things that you hate, can protect speech that is awful and that speech that you don't like. But just because you don't like the things that are said doesn't mean they're not protected. And it's one of the intellectually difficult things with law is that sometimes you're like, I hate that you have the right to say that, but you also have the right to say that. But it doesn't mean you're free from consequences, but those can be societal consequences, people not wanting to associate with you, people not wanting to hire you, not necessarily legal consequences if it is protected speech. That is the point of our First Amendment. Things that make the U.S. different than other places. So the court, also no footnotes in this one. So if we need sassy voice, we're just going to bring it in because there's no footnotes. The court, having taken this matter under submission on a 1/11/2022 for hearing on special motion to strike under CCP 425.16, that's the anti-slap motion, now rules as follows. The court grants defendants special motion to strike plaintiff's first amended complaint pursuant to California Code of Civil Procedure 425.16. I don't know. When I saw it in all caps, it felt like in all of the period dramas when they announce people for the Queen. It felt like that's the voice that was needed. Like, I am now announcing Lady Bridgerton. That's the voice that I hear in my head. That's what's happening. That's what's happening up in there. Background. The judge did a great job of summarizing the background, and I love. Plaintiff Triller filed this complaint on July 19th, 2021, saying that Ethan Klein's super lame and stuff. Plaintiff asserts causes of action for 1, intentional interference with existing economic relationships. This is not IIED, which is intentional infliction of emotional distress. This is IIEER. Damn it, why are these causes of action so long? 2, intentional interference with prospective economic relationships. 3, negligent interference with existing economic relationships. Just note in mind, existing being an operative word here. Negligent interference with prospective economic relationships, violation of California Business and Profession Codes 17200 et sec. In its complaint, plaintiff alleges that defendant published 4 videos on the H3 podcast containing false, misleading, and malicious allegations concerning Triller Inc., the Triller app, and Ryan Kavanaugh, heretofore related in the lawsuit as Mr. Kavanaugh, heretofore referred to by me as Cav. Because why not? Additionally, defendants are alleged to have encouraged their fans to leave 1-star reviews of the app. On November 19th, 2021, the court held a hearing on defendant's anti-Slapp. I covered that hearing here because there's a transcript from it. And if you want to know the transcript of that, there is a H3 playlist on the channel of all the legal proceedings that I've covered, and it is in there. So that if you want to hear the transcript and what went down, you will see that the court was leaning towards this ruling back on November 19th and gave Triller a lot of grace, just a lot of grace. The court held a hearing on defendant's anti-Slapp motion. The parties presented oral argument. At the hearing, plaintiff requested the opportunity to provide additional evidence. Courts don't generally grant that. Courts generally say, yo, you knew what this was. You knew what you had to do. You know your burden. You're not new. This is standard operating procedure. Get your shit together. You don't get a second bite at the apple. This court said, okay, Triller, you have one more chance. And we'll talk about how they used that one more chance. The court ordered further briefing on the submission of late filed evidence. December 2nd, the court permitted further evidence and briefing. The court, and all of this, by the way, raises the attorney fees that Triller's now going to have to pay back to Ethan Klein. Or could have to pay back, I should say. It's not a foregone conclusion. The court can decide the amount of attorney fees. But the court permitted further evidence and briefing. The court ordered plaintiffs' supplemental brief and evidence not to exceed 10 pages. Y'all that have been watching all of this coverage know what direction this is going in right now. The court was like, let me remind you for just a moment when I said that your page limit was 10. Let me just remind you of that. Plaintiffs' supplemental brief and evidence not to exceed 10 pages, to be filed and served on or before December 7th, 2021. Defendant's responsive brief, not to exceed 10 pages, was to be filed and served on or before December 14th, 2021. On December 2nd, plaintiff Triller submitted a supplemental declaration of its general counsel, M. Darren Traub, with 4 exhibits totaling over 800 pages. Triller, why? When the judge says 10 pages, 800 is never an option. It's just not an option. I don't know how many times over the page limit that is. That feels like a lot of times over the page limit, like 80 times over the page limit maybe, but I'm not good at math. I went to law school. This is a lot of pages over the page limit. And the court's already giving Triller a whole lot of consideration. The court already said to Triller, we don't give second bites at the apple. You know what this motion is, but we are giving you additional consideration. Don't fuck it up. And Triller went ahead and said, here's 800 pages of graphs that don't make sense. The court loved this. If I was the research attorney that received 800 pages when the page limit was 10, I would have yelled to all of my colleagues about these attorneys. And then I probably would have put their name on the list of attorneys I don't want to ever see anything from again. That's just me, though. That's just me, though. Anti-Slapp motion standard. We will go through the law of it all pretty quickly. A lot of you aren't practicing lawyers and just don't care what the law of it all is. So we will go to the important stuff. First, it's the defendant's burden to show that the lawsuit arises from exercises of free speech. Ethan Klein's team has to show that they are being sued for free speech. So Ethan has to prove that the issue is arising. Oh, this is not what I wanted to do. Sorry, y'all. I clicked improperly in the back end of my video, but that's all that's in my description box. If you want to go see the description box, you got the front and the back end. So, how did I get here? My hand is literally running away with my brain. Where's my motion? We're back. Motion. So with that, Ethan Klein's side, team lawyers, has to show this arises from free speech or petition. We're not talking about petitions today. And then the burden shifts to the plaintiff who filed the suit to prove, and that's where we're getting to. Defendants need only make a prima facie showing that the activity arises from free speech. Prima facie is a fairly low standard. It's a facial showing on its face, a reasonable probability, like a math standard. It's like, I am sorry, Emma England. I know I will go into enough of the law, but if you want to see the case sites, they're all up here. I don't mean to disparage. I'm just letting you know that the shade and the tea is what we are focusing on sometimes. Not all of the, Kajimi Engineering and Construction Inc. versus the city of Los Angeles of it all. So the defendants, Ethan Klein, make a showing of reasonable probability of yeah, it seems like it, that the activity arises from free speech. A podcast on the internet is kind of easy to get there. Once that showing is made, the analysis shifts and the burden shifts to the plaintiff, the person who filed the suit, to show a probability that they will prevail on the merits. So then the plaintiff, Triller, has to prove that there is a probability, like a more likely than not probability, that they will prevail on the merits. You have to show that you can prevail and that the case is allowed to go on. The entire purpose of Anti-Slapp is so that people who are being silenced through litigation have a mechanism to pull the escape hatch before they spend a year spending money in discovery, before they rake up the cost to defend this lawsuit that shouldn't have been brought in the first place, because it cannot succeed because the activity is protected activity. So there's no way they can win. Yeet immediately. And it is a cost-saving measure to discourage litigation used to improperly silence people. If someone is defaming someone, an anti-slap motion won't get granted because the defamation will be provable. So, sorry if we're like whiskey ice ASMR, apologies. Plaintiff needs to show that its complaint is legally sufficient and supported by, what is this word other than my favorite word? Supported by facts. Supported by facts to sustain a favorable judgment. Can you win? Put another way, the plaintiff must demonstrate that the complaint is both legally sufficient and supported by sufficient prima facie showing of facts to sustain a favorable judgment if the evidence submitted by the plaintiff is credited. In making this assessment, it is the court's responsibility to accept as true the evidence favorable to the plaintiff. The plaintiff need only establish that his or her claim has minimal merit to avoid being stricken as a slap. The court takes every reference that the plaintiff makes as true, even if it might not be proven to be true down the road. The court takes everything in the light most favorable to the plaintiff to find a minimal merit in the lawsuit. And some of you might be like, well, minimal merit, how hard is minimal to meet as a standard? Well, we'll get into it. At the, quote, second stage of an anti-slap hearing, the court may consider affidavits, declarations, and their equivalents if it is reasonably possible that the proffered evidence set out in those statements will be admissible at trial. Reasonably possible. That's not a hard standard. Is it reasonably possible that the declarations can be admissible at trial? Conversely, if the evidence relied upon cannot be admitted at trial because it is categorically barred or undisputed factual circumstance show inadmissibility, the court may not consider it. Plaintiff's supplemental evidence, Plaintiff Triller, Exhibits A and B. Let's talk about the evidence. Let's talk about the facts. Let's talk about, never mind. Keep reading, Emily. Lawsuits, we're talking lawsuits. The Traub Declaration states Exhibits A and B, respectively, are true and correct copies of Apple App Store and Google Play Store logs tracking various data points in the Triller app's one-star reviews during the time period at issue. Whose business records are those? I don't know. Maybe Apple's and Google's. Perhaps. And the court addresses that because it was one of the things I asked. It's like, is there foundation for these? Because these aren't business records from Triller. These are business records from like Apple and Google, and they didn't subpoena Apple and Google. The court determines that these documents are not submitted for the truth of the matter asserted, but rather to show that the reviews were made. So not for the truth of the reviews, but to show the reviews happened. As such, exhibits A and B are not hearsay. At this time, however, they lack foundation. Huh. Weird. 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 They lack foundation because they didn't come from Apple and Google. They came from Triller. Because plaintiff has not demonstrated, plaintiff corporate counsel for Triller in their declaration has not demonstrated personal knowledge as to when the documents were created, the mode of preparation, the manner in which the documents are maintained to indicate the exhibit's trustworthiness. And by the way, this basis of foundation, when we were talking about foundation in the Rittenhouse trial, this is what I was yelling about then too. Foundation is laid out in the evidence code. We all know what needs to be met to have foundation. Elle Woods was sitting in her 1L class going, you need like reasonable belief that your claim has like evidentiary support. We all know this to be true. This, y'all legal muggles, we all know this to be true. But these are the steps to foundation that are an inextricably linked basic foundation to the practice of law. Just so we know that this is not like an amorphous standard. Like, where did this come from? The evidence code. That's where it came from. Because this evidence is within the control of third parties, the court finds plaintiff through depositions of custodians of records or live witnesses has a likelihood of establishing Apple and Google authentication at trial. This is a generous read. I think the court is right in reading it this way, but it is a generous read. And the court supported that with case law up above, that if it's likely that the statements will be admissible at trial, then the court can consider it. And the court's saying, look, there are ways to get a foundation for this. It's not hard to bring in a representative from Apple and Google. So we are considering exhibits A and B. Exhibits C and D. Exhibits C and D are Triller's internal documents for which plaintiff has custody and control. Your documents, Triller. It could have, oh dear, the court's saying what you could have done was, that means you didn't, but you could have. It could have obtained declarants, people issuing declarations, with personal knowledge to establish the documents are what they purport to be. Foundation. And to satisfy the elements of a business records exception. That's a business records exception to the hearsay rule. There is no description of the mode of preparation. Again, this is in the evidence code. Law students everywhere are like, a business records section. You need like mode, time, manner of preparation. The mode of preparation of either exhibits C and D or the damages listed in the two declarations of general counsel. General counsel does not provide specific information on the manner, time, and mode of preparation of these documents. You know, the things you need to do to establish foundation. The court infers that Traub is Triller's new general counsel. Whenever the court has to infer, they're going to be annoyed by it. Tell the court what they need to know. Don't make them play guessing games, peekaboo with you. Because if the court has to play peekaboo with your evidence, the court is out. They're like, I'm not peeking. Boo. We're done. Triller's new counsel, as there was a different general counsel, Brian Blatz, who signed the previous declaration on September 29th, 2021. Maybe tell the court, who the fuck is you? This is not a game of who the fuck am I? This is a game of who the fuck are you? Sorry. Brian Blatz, who signed the previous declaration of September 29th, 2021. So the court's left to assume, and the court is annoyed. Similarly, Mr. Blatz's declaration does not provide the requisite foundation for the exhibits for the same reasons. Law nerds, you are the greatest, and I love you deeply. Mr. Blatz and Mr. Traub Blatz Traub. We need a third name for the law firm of Blatz Traub and something else that sounds like a bodily function. Isn't Blatz the name of one of the villains in one of the Minions movies? Anyway, Blatz and Traub failed to establish the personal knowledge of how exhibits C and D were prepared. Specifically, how the damage calculations were determined. How did you decide how much money you said is lost? By whom? And the time of the preparation. Like, when did you decide this? Was it as of September? Was it as of November? Was it as of right now? When did you decide? Traub's conclusory statements, oh dear, you just assumed shit and the court's not having it. Not having it. Not at all. And then I lost my place because I was excited by the court's sass. Let's see. At the time, Traub's conclusory statements calling out you just are assuming shit. Traub's conclusory statements regarding exhibits C and D being business records does not satisfy the business records exception. You can't just say these are business records. You have to prove that they are business records. Assuming the exhibits are compilations of data, a proper foundation for authentication has not been met. Counsel, please just do your job. Please. It's just time and manner of preparation. Like, how? And that's what we all asked when we went through the 800 pages. We were all sitting here, well, me particularly, drinking whiskey going, how? Why? So the court's just saying you failed to meet the basics. Presumably plaintiff could have, right, because they work for the company and these are the company's records, produced a declaration from an employee, expert, or accountant who had personal knowledge of the document's calculations and modes of preparation. There is no context. The judge and I are on the same page with this one. There is no context submitted for exhibits C and D. Those were the wonky graphs. And the damage calculations that would provide adequate foundation for the court to determine the authenticity and reliability of the documents. Triller, I told you 10 pages. You took 800 and you still didn't give me any foundation or context. What are you doing? I don't understand. Could you explain it to me? Because I don't want to guess. The court infers. When the court has to infer, you have probably lost. The court infers these exhibits were summarized or compiled for litigation based on the title of the documents and the fact that plaintiff did not provide evidence as to when the two exhibits were prepared. Specifically, the information provided on the conversion rates and cost are too speculative, absent a clear showing on how the data and resulting damages were calculated, including a person with knowledge of the time and mode of preparation. Again, reminding counsel of the basics for a business records foundation. However, in arguendo, even if the court were to consider and credit all four exhibits, the court finds plaintiff has not met its burden here. Even if I give you all of the grace in the world, if I considered everything you showed me, you still haven't met your burden. So sorry. Analysis. I hate the spacing on this so much. Analysis. Like, can we get a space here and put just analysis right there? Could we just maybe? I'm not being picky. Your Honor, I'm not being picky. I apologize. I love your work. Sorry, we're just going to keep going. In assessing a defendant's section 425.16 special motion to strike, Anti-Slapp, the court must engage in the two-step process. We know the two-step process. This burden may be met by showing the act which forms the basis for plaintiff's cause of action was an act that falls within one of four categories of conduct set forth in that code section. If the defendant meets the initial burden, the burden shifts to plaintiff. Statements at issue. Should we read them all? I think we should. Ooh, we can use the footnote voice for the statements at issue. Let us do that. Statements concerning Ryan Kavanaugh. Let us remember for a wee moment. Ryan Kavanaugh is not a plaintiff in this lawsuit. Triller is the one suing in this lawsuit. So why are the statements regarding Ryan Kavanaugh relevant? Let's all ponder on it together. You're not going to be able to come up with a reason because just like they're not relevant. They just felt like they wanted to put them in the lawsuit. Statements concerning Ryan Kavanaugh. Footnote voice. Mr. Kavanaugh runs a Ponzi scheme. The defendant misrepresented a June 7th, 2019 article in Variety magazine. Oh, I should make a disclaimer. I am not making these statements. This is a legal ruling protected by litigation privilege. The judge is saying this, not me. These are the statements at issue. Start over. Mr. Kavanaugh runs a Ponzi scheme. That defendant misrepresented a June 7th, 2019 article in Variety magazine. Mr. Kavanaugh bears a physical resemblance to Harvey Weinstein. I can't not laugh. Mr. Kavanaugh sued defendants. That's a false. What? Okay. Statements by Reddit users. Take down Triller. Let's all rate Triller a 1 on the App Store by Reddit user/conversation actual 77. Foot soldiers. Time to bank down Triller app. Called by the king himself. User 2pokeus2. I feel like these should be screamed because they're in all caps, but I'm in the footnote voice and now I'm having an internal conflict. We're going with the footnote voice. Foot soldiers assemble. Tank the Triller app. There needs to be a comma. We can do better than this by Reddit user. You don't blame me. 13. Image shared by Unnecessary Yak. Triller went down. 1 star in the App Store. Keep up the honest reviews, foot soldiers. Posted by Reddit user. You Miss Roderick Heffley. Statements concerning Triller and the Triller app. Triller falsely represented that comedian Kevin Hart uses the app. Keep that in mind for later. The Kevin Hart of it all. This judge had to sit there and do this, by the way. The judge did that. Well, probably the research attorney. They did this. This is in court. Was Kevin Hart a user of Triller is in a legal document. This is in an official ruling. I can't. That app is flipped. Yo, Triller! My thing is flipped. Comment made originally by Mr. Beck as he was creating a video using the Triller app. This is in a lawsuit. I can't. Okay. So, I've been having a fun look up Triller. I've been having fun looking up Triller. Like, if you go to the App Store, I have them 1 star, by the way, just because I don't have a positive experience. Yeah, but people should judge for themselves. Go download the app and leave a review. I'll be checking in on the Triller reviews. Try the app, see how it goes, and give it 1 star or more, 1 or more stars, some amount of stars between 1 star and up to maybe 5 stars. Download Triller and rate it 1 star or more. That's what I did. We do not condone and we do not encourage troll reviews like this one. Those are the statements at issues. Great. Okay, we're going to breathe. The First Amendment is no laughing matter. But this doesn't even get to the lawsuit where one of the statement issues is whether or not some fake person pretended to be Keemstar's girlfriend and went on the H3 after dark and said that Keemstar cried after sex. Like, we're not even to that suit yet. That's at the other suit. But one day we're going to have to do this all again with the other defamation suit. Oh, God. Okay. Protected activity. A defendant satisfies the we've lost. A defendant satisfies the first prong by demonstrating that the act underlying the cause of action fits in the category spelled out in the code, including, the First Amendment. The moving party need only make a prima facie showing that the targeted statements were made in a public forum. I'm literally crying. In a public forum in connection with an issue of public interest. And that's what they're going to try to evaluate. Were the statements above, yo, Triller, my thing is flipped. Were the statements above statements made in a public forum in connection with public interest? And yes, y'all, Triller argued that the internet is not a public forum. That happened. Somebody typed that and then submitted it to the court. Public forum. Like the court said in Wilbanks, this court views the internet as a public fucking forum. The internet is a classic public forum. It permits the exchange of views in public about everything from the greatest issues of war, peace, and economic development to the relative quality of the chicken pot pies served at competing family restaurants within a small neighborhood, to whether or not Wendy's can roast you and whether or not Colin or Cuthbert is in the wrong. The internet is a glorious wide place. Plaintiff argues, Triller, that the website at issues are not public forums. You know, YouTube and Reddit are not public forums. We're not going to spend much time on that because I'm just like, no. Plaintiff supports its argument by citing Weinberg. That is a case. But Nygaard, a different case, not Sophia, criticized that whole, but wouldn't it be great if it was like, no, but Sophia Nygaard said, no, nay, that's not how that goes. Nygaard criticized the holding and concluded that, quote, nearly all publicly available written communication traditionally has been made in fora that are, plural forms. Who knew that without going to law school? That the plural for forms is fora, not like flora and fauna, but fora. Forms doesn't work. In law, it has to be fora. So people are like, what is that word? Yep. Made in fora that are subject to editorial control and thus would not come within the narrow definition of public forum articulated in Lafayette, Morehouse, and Weinberg. But the court is citing cases that disagree. This is the part of going to law school where you have to go and say, okay, this judge said this, but this other judge said this, and this one's right, this one's wrong. So follow this law, not this law. This is 90% of law is finding the case that supports your position and saying why it's distinct, different, or distinguishable from the other case law. So the Nygaard case was nay. As we now just quote Bailey Sarian. I watch a lot of YouTube, but it was no, that the internet is generally a public forum. Accordingly, this is the court's ruling. This court finds that YouTube and Reddit are public forums. Duh. The court wants to say duh, but they can't because they have to be professional. But the court wants to say YouTube and Reddit are public forums. Duh. As defendants argue here, podcasts are available freely to the public on YouTube. And then they go into all the arguments supporting that YouTube and Reddit are public forums. They are correct. They are public forums. Public interest. A public interest is any issue in which the public is interested. To satisfy the first threshold, the offending comments must have been made in connection with an issue of public interest. And then they go on to cite case law saying that under the California Supreme Court's decision in FilmOn.com Inc., it is not enough that a statement refer to a subject of widespread public interest. The statement must, in some matter itself, contribute to the public debate, which is interesting. That the statement can't just be commenting; it has to contribute in some way. The court finds that the statements at issue here are those of public interest. These are statements that contribute somehow to the conversation. The comments made on the podcast relate to the user experience of the Triller app. The court is now validating the statements made on the H3 podcast. The court finds that the statements at issue here are those of public interest. The comments made on the podcast relate to the user experience of the Triller app. The Triller app and CavCav have been the subject of numerous media articles. The app has had millions of downloads with millions of active users. These facts alone are sufficient to show that the statements relate to matters concerning an entity in the public eye or a topic of widespread public interest. Triller is a competitive app to TikTok. This is a matter of public interest. Instructive here is Daniel versus Wayans. When I say Wayans and you hear like the Wayans brothers, yes, you are correct. And I'm going to talk about this case law because it's interesting. There, in that case, Daniel versus Wayans, the comments at issue referenced a Twitter and Instagram account that had more than 1 million followers. Defendant Wayans was a popular actor, writer, and producer with many film and television shows to his credit. Further, the post at issue also included information about an upcoming movie, A Haunted House 2. The court held the, quote, post both referred to a topic of widespread public interest, the film, and contributed to the public debate or discussion regarding the film by giving fans and those interested a glimpse of someone in the film. Analogous to the facts here, the Triller app has millions of downloads. There have been considerable press regarding Triller Fight Club 2. Even Triller's majority shareholder, CavCav, a non-party here, has been the topic of many news articles regarding his business dealings and personal life. Defendants cite to various articles, including Variety and the New York Times, regarding Triller and CavCav. If a Twitter and Instagram profile with millions of followers constituted public interest, then the Triller app with millions have purportedly downloaded, and a company that promotes fights with Jake Paul, a famous YouTube celebrity, also satisfies the criteria under Daniel. Yup. Triller argues its corporate activity is not an issue of public importance. The court yeets this argument very quickly. The court finds that the statements at issue do not relate to corporate activity and such as financials, but rather relate to the larger community of Triller's app and the content that Triller makes available to the public. Second, the court is not persuaded as Triller's promotional activities and media coverage contradict Triller's position. Yo, Triller, if you think that you're not a matter of public interest, then why are you marketing your app? Plaintiff submitted evidence. Talk about using your own words against you. The court's like, no, I'm using your own evidence against you. Listen up. Plaintiff submits evidence that Triller spends significant time and resources on its marketing campaigns. Such promotional activities like promoting the app through ads and promoting Fight Club 2 with Jake Paul indicates that Triller itself must believe the public is interested in its activities. Triller, either you're a matter of public interest or you're not, but you can't argue that you're not a matter of public interest and then submit documents showing that you spend hundreds of thousands of dollars on advertising and that it's costing you more because of Ethan's statements and then say that you're not a matter of public interest. No. Negative. So the court used their own evidence against them. During the November 19th, 2021 oral argument, Triller maintained that defendant's speech was not in furtherance of public discourse because defendant's manner, Ethan's manner, defendant's disposition, while making statements such as "try it yourself," communicated insincerity. Your Honor, I deeply believe that Ethan Klein was making fun of us. And that's just not in furtherance of the public discourse. Someone argued that, essentially, in court. That the "try it yourself" was insincere. That's where we're at. That's what they were arguing in court. Yeah, but Your Honor, he didn't mean try it yourself. He meant make fun of our app. Oh my. Full chest when the no, I'm representing the best interests of my clients. Huh? Uh-huh. The court declines to infer a hidden meaning and will only consider the words spoken by defendants in the podcast. The court finds defendants' statements concerned issues of public interest and are therefore protected speech. Klein has now won the first prong. So we find that this is protected speech. Therefore, the burden shifts to Triller. Prove that you can win. Prove that you have a mere minimal probability of winning. Prove like just the tip. Show me just enough to keep me interested. Just enough to show me that I think that maybe someday you might be able to win this. Just a little bit. Probability of prevailing. Once defendant makes a prima facie, which is way harder to say after whiskey than before whiskey. If you're ever talking about prima facie in like, the bar at 2 a.m., it's harder later. The prima facie showing that the plaintiff's complaint arises from constitutionally protected speech. The court finds that it does. They say, however, a plaintiff seeking to demonstrate the merit of a claim may not rely solely on its complaint, even if it's verified. Instead, its proof must be made upon competent, admissible evidence. Speculative inferences not supported by the evidence proffered need not be considered. So the court is citing to case law in Monster Energy Co. versus, does that say Shatner? There's no way I'm pronouncing that properly. Monster Energy, whoever Monster Energy sued. So the court is quoting the Monster Energy case, saying that speculation will not be considered. Underlying defamation and incitement claim. Did Ethan incite his audience to action? For plaintiff to show a likelihood of success on the causes of action, before I get all the way to this, I should just say, this is like a two-prong analysis for each cause of action, because the court looks at the cause of action, and for the cause of action to be met, there has to be underlying action. So for there to be like this intentional interference, the intentional interference has to also be an action. And that action here is either defamation or incitement. So the court has to go, okay, this cause of action is here and you've got to prove this, but underlying it, there must be defamation and incitement. So even though defamation is not claimed in this lawsuit, it's kind of the underpinning and foundation of all of these causes of action. Did you just see me switch into full like lawyer mode from like kind of snarky mode? Yeah, that happened quickly. We're going to go back to snarky mode. Don't worry. So that's why the court is talking about defamation and incitement. It's the foundation under these causes of action. So it's like, you got to prove this, but you got to prove that. Thus, the underlying wrong alleged must state a cause of action for either defamation or incitement that underlies every single allegation. The elements of defamation are publication that is false, defamatory, and unprivileged, that has a natural tendency to injure or causes special damage. Libel is a false and unprivileged publication by writing, printing, picture, effigy, or other fixed representation to the eye, which exposes any person to hatred, contempt, ridicule, or no, it's just not happening. Y'all, those of you that are new, I am both ADHD and dyslexic. Sometimes pronunciation is hard. That we're just not even going. We're not even going to try. Or which causes him to be shunned or avoided. Which actually, as we're talking about the Cardi B suit, I think when we're talking about defamation per se, the allegation that someone has a communicable STD could be something which causes someone to be shunned or avoided. So I might have to rethink my per se analysis. Anyway, anything that has the tendency to injure them in their occupation. They go on to other courts. So we're talking about defamation and what is and is not defamation. Oh, we're getting to, okay. Wong versus Jing. The sine qua non of recovery for defamation is the existence of a falsehood, because the statement must contain a provable falsehood. Truth is a defense. Period. If your shit is flipped, saying it's flipped is not defamatory. Because the statement must contain a provable falsehood, courts distinguish between statements of fact and statements of opinion. Saying someone is a piece of shit is an opinion. Also, hyperbole. Humans aren't literally made out of feces, right? It is not a statement of fact. Where a statement of fact could be something like saying someone, removed their mother from life support to take their inheritance, perhaps. Something like that might be a statement of fact. So the sine qua non of recovery is the existence of a falsehood. So you have to parse between facts and opinion. Although statements of fact may be actionable as libel, statements of opinion are constitutionally protected. That does not mean that statements of opinion enjoy blanket protection. On the contrary, where an expression of opinion implies a false assertion of fact, the opinion can constitute actionable defamation. And this is where the gray zone comes in. Like saying, well, I believe so and so is a predator. Just my opinion. That might not be protected. So it might be stated as an opinion, but it's really a statement of fact, right? Well, I think this. It depends on what you say next. Though something that would be more protected is like, a lawsuit says this, an article says that, but there are times where re-reporting can also be defamation, and this is why lawyers have jobs, right? Because it's like, well, yes if A, but no if B, but kind of maybe it depends if A, B, C. Lawyers. To determine whether a statement is actionable fact or non-actionable opinion, courts use the totality of the circumstances test. This is why when people are like, look, it's true, it's opinion, it's whatever, it can still be expensive to defend it because the court has to say, we look at the totality of the circumstances as to whether the statement in question communicates or implies a provable false statement of fact. Under the totality of the circumstances test, this is a test. This is only a test. First, the language of the statement is examined. For words to be defamatory, they must be understood in a defamatory sense. Next, the context in which the statement was made must be considered. The First Amendment protects parody, rhetorical hyperbole, and loose, figurative, or hyperbolic language. Saying something like, I'd rather get a colonoscopy from a chain link fence than use this app is generally going to be figurative, hyperbolic language. I'm just saying. Plaintiff has provided evidence that negative reviews were left in the Apple and Google app stores using similar language as the podcasts at issue to show that defendants directed their fans to commit wrongful conduct. That evidence, however, is insufficient to show a likelihood of success on the merits for incitement because while they provide evidence of negative reviews, they do not put forth sufficient evidence to establish defendant directed or ratified tortious activity. Defendant states in the podcast that fans should not leave fake reviews and condemns such behavior. While plaintiff argues Mr. Klein's demeanor communicates something more sinister, the evidence put forth does not show that Mr. Klein authorized or ratified tortious activity. Tortious just means actionable activity. Plaintiff does not provide evidence defendant's statements were false or not opinion. Plaintiff Triller does not prove like this statement is it. Plaintiff Triller does not prove that Ethan Klein's statements were false or not opinion. Yo, Triller, you didn't prove that your shit wasn't flipped. In fact, the court references that. Let's get into the Kevin Hart and the my shit's flipped of it all right now. In this context, the court finds that the language used by Klein is more akin to parody, hyperbole, and primarily statements of opinion. Even if Klein's statements directing H3 fans to download and try Triller's app were not genuine, there simply does not lie a cause of action for defamation. Do as I say, not as I do as I do, not as I say, is not an assertion that can be proven as fact or opinion. In the context of defamation, plaintiff has not met its burden of showing a probability of success on the merits. Statements concerning whether Triller falsely represented comedian Kevin Hart is a statement that can be shown to be true or false. Defendants Klein, have put forth evidence to support their prima facie showing, their on the face showing, that this was a true statement at the time the podcast aired. The true statement being that Kevin Hart doesn't use the app. Despite not having a presence on the Triller app, the court's just going there. Despite not having a presence on the Triller app, the description of the Triller app stated millions of users have made Triller videos along with stars like Kevin Hart. Mm-hmm. 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 The plaintiff Triller has not put forth evidence to meet its burden showing a likelihood of success on the merits that this particular statement was false. Well, there it is. Let's continue, shall we? A statement concerning the app was flipped is also a statement that can be true or false. Your shit was flipped or it was not. Defendants have put forth evidence that a statement was originally made by Mr. Beck. Hello, Mr. Beck. Do you think Mr. Beck even knows how much he's been mentioned in these lawsuits? I have to imagine Noah Beck is somewhat tangentially aware, but maybe not. This statement originally made by Mr. Beck while he was trying to record using the Triller app. Mr. Beck observed that the app had flipped the camera. Plaintiff Triller provides evidence that the app had a inversion problem relating to camera function on certain iOS devices. This is from the lawyer's declaration. Thus, because it contains an assertion of fact, it is not actionable as defamation because plaintiff must show the statement is false. Plaintiff has failed to provide evidence to meet its burden of showing a likelihood of success on the merits of this statement because plaintiff provided evidence showing, in fact, that shit was flipped. So there's that. The court was like, look, I'm not persuaded because your declaration says, well, there was an inversion issue. Yes, inverted, flipped, international communications. Sorry, that just harkens back to Top Gun. Because I was inverted. That's Triller. Triller's just going, because I was inverted. The remaining statements were posted on the H3 subreddit, which identified itself as a social networking site, Reddit, and permitted users to create their own profile and post information on various forums. No evidence is offered to support the contention that the H3 podcast, Ethan Klein, Ela Klein, or Teddy Fresh created the comments. Did Ethan say that? Did Ela say that? Did anyone you're suing say that? No? Okay, fuck off. Plaintiff Triller cannot successfully assert a cause of action for statements concerning Mr. Kavanaugh. Sorry, Cav. In defamation actions, you have to be a plaintiff. Here, insofar as any statement is of and concerning Cav, those statements do not show a likelihood of success on the merits because Cav is not a plaintiff in this case. Sorry, you didn't sue here, so statements related to you are irrelevant. Note, the court did not evaluate the statements made about Kavanaugh because Kavanaugh's not a plaintiff here. So when we get to like, what does this mean for the Kavanaugh Klein defamation suit. We'll talk about that in a little bit, but the court's not saying these statements between Kavanaugh and Ethan won't suffice a claim. The court is saying, you're not a plaintiff. Why are you even here? The court literally said, she doesn't even go here. That is what the court said. That is the court's ruling as to Cav. She doesn't even go here. Intentional interference with contractual relations. The elements the plaintiff must plead are a valid contract between plaintiff and a third party. This is key. Keep this in mind. Defendant's knowledge of this contract. Defendant Klein. Defendant's intentional acts designed to induce a breach or disruption of the contractual relationship. Actual breach or disruption of the contractual relationship, resulting damage. This is a very proper cause of action when you have something like going after people's sponsors. So this can be, and I think in the future we will see intentional interference with contractual relations where you see someone saying, hey, creator A has a sponsorship with sponsor whoever. All of my audience reach out to this sponsor and tell them they should not work with creator A. Could creator A sue creator B for directly going after that contract? Because in statements like that, hey, I know this creator, I know they have a sponsorship with, sponsor, and I'm telling my audience, do you want to let that sponsor know what kind of person creator A is? That is a creator intentionally trying to break a contract that exists. They're saying that they're aware of it and they have taken action to induce a breach or disruption of the contract. This cause of action, I think we will start to see more in intentional interference with contractual relationships, which is why all creators should be very careful when saying, oh, they're sponsored by so-and-so, go tell that company how you feel. If a sponsor looks at, and we covered this a little bit in the Amanda Ensing case, like Sephora stepped away from Amanda Ensing because she had made statements on her social media. It wasn't that the public was calling her out, though they also were. It was that the brand itself was like, this doesn't align with us. That's different than a creator coming for a sponsor. And this can cause problems down the road. People forget this cause of action exists. What you can't do, though, is say that hey, me sitting here, I have not downloaded Triller. I barely use TikTok. I don't need a TikTok ripoff. But you can't sue saying, I didn't download Triller because I listened to the H3 podcast. I didn't download Triller because I have no interest. But I'm not in a contract with Triller. I'm not a paying customer of Triller. I didn't stop using Triller because I heard what was said on the H3 podcast. It's different than telling someone not to go buy a product from a brand. Hey, you had a recurring subscription for Halo Beauty and you canceled your recurring subscription because you heard somebody talking about Toddy Westbrook or Halo Beauty or saying that it was snake oil or whatever. So you canceled that. So could that be intentional interference with contractual relations? Maybe can. So as we go forward, and that's because we covered that lawsuit, that is why that example came to mind. So they go on to say plaintiff has submitted evidence stating that the thousands of one-star reviews parroting defendants' allegations have had a detrimental effect on the app. Well, isn't it funny that Triller's like, well, it worked, Ethan. You talked some shit about us and your audience made a bunch of one-star reviews and it definitely had an effect on us. So you win. The problem is it's not a recoverable action. So now Ethan knows that it affected. I don't think Triller understands all the way how social media works when people have audiences that are loyal and dedicated. I think that they were not expecting what happened. According to plaintiff's internal analysis of the damage caused by defendant's conduct, this is Triller saying this is what Ethan's statements on the podcast caused. That their internal analysis of the damage caused by defendant's conduct, the 1,000 of one-star reviews parroting defendant's allegation have 1, depressed the overall rating of the app, and 2, depressed the conversion rate. converting someone from a, hey, I might download this app to a customer, or the percentage of consumers who choose to download the app after viewing it in the App Store or Google Play Store. The Blatz declaration states because Triller expends significant time and resources on its marketing campaigns, though they're not a public company, just they argued both sides of that. The depressed overall rating and depressed conversion rate have caused and are continuing to cause Triller significant harm and millions of dollars in damages. However, in the declaration of Darren Traub, filed in support of plaintiff's supplemental evidence, it states Triller has incurred approximately $927,000 in increased conversion cost as a direct result of defendant's conduct. It also states that Triller has additionally incurred approximately $615,000 to mitigate the damage caused by defendant's conduct. Go ahead and add whatever Ethan's lawyers cost to this tally. Just my opinion. Finally, plaintiff states defendant's actions have caused additional damages, including reputational damages and damage to Triller's goodwill that Triller is not yet able to quantify. A cause of action for intentional interference with contractual relationships requires the plaintiff to provide evidence, facts, of a valid contract between itself and a third party, like the sponsor creator example that I gave. At the November 19th, 2021 hearing, counsel for Triller explained the contractual relationship in each of these causes of action is between Triller and either, it's got to be one or two, and either actual users of the app or prospective users of the app. If they are prospective users of the app, don't pass go because there isn't an actual contractual relationship. Where is the valid contract? Has anyone in the chat used Triller? Do you have to pay to use Triller? Is Triller a free app? Tell me if Triller's a free app. Is there consideration for that contract? But a valid contract. A prospective user can't have a valid contract because they're prospective. They don't have an agreement with Triller yet. They haven't started using it yet. But at all times, we are arguing, Triller, that defendants are interfering with a relationship between Triller and users of the app. If they're prospective, they're not actual users. And that's the source of Triller's profits. Were the court to consider and credit, like actually consider and give credit to all of plaintiff's evidence, it still does not find plaintiff has made a prima facie minimal showing of an identifiable existing contract between plaintiff and a third party. Who's the person? Who did you have a contract with? Oh, nobody. The court is left to query Triller's business model and whether app users pay Triller for use of the app. Are there in-app purchases? Do you pay? Is it free? Does Triller make its money on advertisers showing ads? How does Triller make money? And if Triller gets paid by advertisers like TikTok does, then the user, the end user, is not who the contract is with. The contract is with the advertisers. So if you had an advertiser say, hey, I'm Dunkin' Donuts. Hi, I'm a huge fan of the H3 podcast. I heard the things they said about you, Cav, Triller, and we're no longer advertising on your app. I know we were doing advertisings. We had a 6-month contract. We were paying this much a month, whiskey. We were paying this much a month for advertising, and we're breaking our contract with you because of what was said on the H3 podcast. Then you might be able to start to construct a contractual relationship that was interfered. But you would have to prove that Ethan knew that Triller had some kind of existing contract with Dunkin', which isn't the facts here at all. Not what happened here. Therefore, says the court, plaintiff has failed to meet its burden to specifically identify a contractual relationship. Just one. You did not at all. Causation. You see my notes, because causation is what I yelled about the whole time I read through the evidence provided by Triller. It's like, how do you prove causation? Causation is the final element of the intentional interference cause of action. Plaintiff must prove that defendants Klein, their conduct was a substantial factor in causing harm. That is normally proven through declarations. And we saw this in the Toddy Westbrook case. We saw declarations saying, I used Halo Beauty. And then I heard statements made, and then I stopped using Halo Beauty. You saw causation in the early documents in early litigation in that case. What we didn't see here was anything even close to that. The court does not find plaintiff's supplemental evidence provides the necessary showing on causation. Agreed. The court is left to speculate as to the factors at play in app user behavior and what variables contribute to an existing app user's decision to stop using the app. Plaintiff has provided a number of possible reasons why the app users may have left Triller. This is plaintiff. Triller has provided a number of reasons why the app users might have left. For example, plaintiff acknowledges that some users of Apple iPhone may have experienced an inverted camera. Flipped. They may have found it to be flipped, frustrating the user's ability to record content. Numerous reviews provided by plaintiff in Exhibit A, this was what I told you the danger was about Exhibit A, make reference to an inverted or flipped camera function. Exhibit A, for those of you that don't remember, was a extensive list of reviews, and we went over the funny ones. But not all of those reviews seemed like they were people who came from the H3 podcast. Some of those reviews were like, this is a TikTok ripoff. Everything's re-uploaded content. It's all just people selling stuff. There isn't anyone here making content. The content's not original. So they included all of those reviews. So the court can look at this and say things like, again, using plaintiff's own evidence against them to say, look, your evidence is part of why I'm ruling against you. Plaintiff's evidence of one-star reviews also demonstrates user dissatisfaction with the design and content of the app, completely apart from anything said on the H3 podcast. The court said, for instance, user Jen736518 left a review stating, I downloaded this app and immediately I started getting emails saying my accounts have been compromised and my passwords have been stolen. I found out many users have had the same issues. The owner clearly knows nothing about running a business or app. Another review example being user BenBoy99, who said, basically, just a terrible wannabe version of TikTok, bro. Basically just used for promotion of brands/celebrities. The content is extremely boring. Do not download if you still want brain cells. You feel? These reviews exemplify the difficulty for the court in discerning causation. The court does not speculate as to whether other potential reasons an app user may have left plaintiff's platform, and the court does not weigh the evidence presented. The court merely points out the speculative nature of plaintiff's damage claim and its failure. The court's merely pointing out that you failed. Take the L. The failure to make a minimal showing on causation. Accordingly, the court finds plaintiff has not established there is a probability that it will prevail on the cause of action for intentional interference with contractual relations. Intentional interference with prospective economic relations. Intentional interference with prospective economic relations has 5 elements. The existence between the plaintiff and some third party of an economic relationship that contains the probability of future economic benefit to plaintiff. An actual user in a contract negotiation. The defendant's knowledge of the relationship, H3 has to know that. Intentionally wrongful acts designed to disrupt the relationship, actual disruption of the relationship, economic harm proximately caused by the app's action. Again, the court does not know because Triller has not proved how it makes money. Triller never said, we make money off of the users. Each user has a lifetime value to us of this. I suspect that Triller makes money off of advertisers. This is speculation because that is how TikTok makes money. It's how Facebook makes money. They make money off of your data and selling your eyeballs to advertisers who want to put their content in front of your eyeballs. So, what they never showed was one advertiser who said, yeah, Ethan knew we were advertising on TikTok or on TikTok, Jesus, on Triller, and we stopped because of things that they said. They can't prove that. You know why? Because that's not the facts here, because they can't prove that. This cause of action requires plaintiff to identify an economic relationship between plaintiff and a third party that probably would have resulted in an economic benefit to plaintiff. Here, plaintiff identifies the third party to be proposed users of the app. The court once again finds plaintiff does not and cannot identify a third party, as those viewing the app in the App Store are unknown potential users to the platform. The court is being asked to speculate as to prospective app user behavior. Even if the court were to consider all of plaintiff's evidence, it would have no way of knowing the identity of the prospective app users and the economic relationship likely to provide future benefit to plaintiff. Plaintiff's evidence also points to reviews favoring TikTok, the dominant social media platform with the majority of current market share. This observation of the content of some of the reviews submitted by plaintiff, your evidence, is meant to illustrate the challenge in proving causation under the facts in this case. As more fully addressed in the section above, this court is unable to find that plaintiff has made the bare minimal showing, prima facie showing, on the elements of damages and causation. Therefore, the court finds plaintiff has not established a probability that it will prevail on this cause of action. The court is going through each and every cause of action and saying, no, no, no. Because the court could say, hey, you've got 5 causes of action. One, I see a probability of success that one can go forward. The rest are yeeted. So the court is going cause by cause to say whether it stays or whether it goes. Should I stay or should I go now? Yep. Okay. Let's get to my favorite one. Negligent interference with contractual relationships. Plaintiff cannot show a probability of a claim for negligent interference with economic relationships because California does not recognize such a cause of action. That doesn't exist. It's literally the court saying that's not how this works. That's not how any of this works. You can't plead this cause of action. This cause of action doesn't exist. And Ethan's lawyers pointed this out, and the defense was like, no, we can too. We can. Yes, we can. So yeah, pour one out for negligent interference of contractual relationships because it doesn't exist in California. Accordingly, plaintiff fails to show a probability of a success on shit that doesn't exist. Triller. Negligent interference with prospective economic relations. The elements of negligent interference are: 1, the existence of an economic relationship. Guess where this is going? Guess which direction this is headed? You're correct. The cause of action is similar to the ones above, that is predicated on the existence of an economic relationship. And guess what? The court says, as discussed above, plaintiff's evidence. What up, Fred? Hey, buddy. We're talking about Triller. Yeah. You want to run away? Yeah, me too. Cool. Plaintiff's evidence only shows 1-star app reviews similar in language to that of the podcast. This evidence does not make the required showing of the existence of economic relationships between the plaintiff and third parties containing the probability of future economic benefits. So as we said above, nope. Negative ghostwriter, the pattern is full. Accordingly, plaintiff fails to show a probability of success on its 4th cause of action for negligent interference with prospective economic relations. Don't worry, we're almost done. Violation of California BMP 17200 et sec. California's unfair competition law provides unlawful, unfair, fraudulent business acts or practices. Section 17200's unlawful prong borrows violations of other laws and makes those unlawful practices actionable under the UCL. Virtually any law of regulation, federal or state or statutory or common law, can serve as a predicate. To claim, sorry. Yes, Fred, I am, yes, we're chin scratching. To plead a claim under Business and Professions Code 17200, there must be allegations showing an unlawful, unfair, or fraudulent business act or practice. To plead this statutory claim, the pleadings must state with reasonable particularity, you have to spell that shit out, the facts supporting the statutory elements of the violation. Plaintiff's claim for BMP 17200 stem from defamation, incitement, and extortion claims. So let's talk about the extortion for a moment. As discussed above, plaintiff fails to meet its burden with showing a probability of success for the underlying claims for defamation and incitement because 1, the statements concerning Cav are not of and concerning Triller. You don't even go here. 2, H3 cannot be held liable for statements made on the H3 subreddit by Reddit users. What a revolutionary concept. You cannot be sued for shit that other people say. No. Who would have guessed? Who would have ever known? That's a stunning revelation. Shocked Pikachu. 3, statements imploring fans to download and try the app without more do not establish incitement because no facts show defendants authorized or ratified such conduct. And 4, statements concerning Triller and the Triller app were demonstrable fact or opinion. Accordingly, plaintiff likewise fails to state a probability of success for... Sorry, Fred is stepping on my soundboard. Thanks, Fred. Thanks, buddy. Appreciate you. Okay. I'm sorry if he's loud. He's banging onto the microphone. He's just rubbing his face on the microphone. Just all in it. Accordingly, plaintiff likewise fails to state a probability of success for violation of BMP 17200 under the theory of defamation or incitement. Then we have to evaluate the probability of success on other merits. Plaintiff has failed to carry its burden of offering evidence to show probability of success on the merits. Plaintiff offers 2 declarations and 2 exhibits showing that some of the negative comments regarding the app store or regarding the app used similar language to the podcast at issue. The court is left to surmise. Never a good look. All right. The court is left to surmise the additional elements for extortion from this evidence. What happened? Where is it? I don't see it. The second prong for an anti-Slapp analysis places the burden on the plaintiff to submit evidence and show a probability of success on the merits. Negative reviews, along with statements from the podcast, do not meet the minimum requirement for showing a probability of success for extortion. To the extent defendant's violation of BMP 17200 is based on a claim under Penal Code 518, plaintiff fails again. Plaintiff fails some more. Plaintiff take the L. Conclusion. For these reasons, defendant's anti-Slapp motion is granted. Defendants are ordered to give notice, which means they have to say, hey, defendants have to mail out notice to everybody. Hey, the court ruled in our favor. You lose. Yay. Flying Fred. Plaintiff's request to amend the complaint. At the January 11th, 2022 second hearing on the anti-Slapp motion, plaintiff requested the opportunity to amend its complaint. The court denies the request. You know why the court denied the request? Because the court gave Triller more opportunities than most courts would and a lot of grace and consideration. And the court said, look, I will give you additional evidence. These are the things you need to prove to me. You have 10 pages. Prove it. Prove causation, prove damage, prove the relationship. Literally bring in a contractual relationship, show how Ethan knew that relationship existed, show that relationship has been harmed. Show me. You have 10 pages. And Triller said, here is 800 pages of stuff. Good luck. It proves things we swear because we said so. And the court was like, that's not how this works. That's not how any of this works. And yeet, your case is done. You're done. You're done. We're done. You're done. We're all done. You're not amending it again. This is the second amended complaint. The court gave a lot of grace. And the court did give a lot of grace. So what happens next for this is that Ethan's legal team will likely file a motion for legal fees, and the litigation will continue over attorney fees. Ethan's attorneys will submit how much they spent on this, the work that they did on this, how much they charge, and say, hey, Triller, yo, Triller, your shit needs to pay. Because part of the anti-Slapp motion is that if you win on the anti-Slapp motion, remember the plaintiff has to show a prima facie, a minimal showing. And so I think the Slapp motion considers that if you have a valid case, you just pushed my mic literally into my face. Thanks, buddy. Okay. That's probably loud for everyone watching. Thanks. I was right in the middle of the sentence. I've lost my train of thought, Fred. You have distracted me with kitty cuteness. So if the case, I think that the anti-Slapp statute contemplates that if the case is solid, it's not going to get yeeted on an anti-Slapp. That anti-Slapp is made to get rid of the cases that cannot survive, because the showing is so low that if plaintiff meets that low showing, the case just moves on. And it only really gets rid of the most, I don't know, pathetic, lacking in evidence, the most arbitrary is a good word, the most arbitrary of the cases. And so with that, I think that's what the statute considers. So now this maybe will be appealed, but with that, I need to look at whether the anti-Slapps can be appealed. But with that, the motion for attorney's fees is what comes next. And the motion will go to this judge, and they will do litigation over the attorney's fees and how much attorney's fees. And the court can grant the entire amount. The court cannot grant the entire amount. The court can say, hey, we think your attorneys charge $3,000 an hour, which I'm guessing they don't. But hey, even Viv doesn't charge that much. Like, that's out of step. Like, you're just padding how much you spent. You didn't really spend that much. So that's not okay. So the court will look at those things. So this is not done. Lawyers' fees come next. Okay, buddy. I will pet you. You just lay there and I will pet you. We're good. So lawyers' fees is the next. But Triller's not done yet. There was another big win that we didn't talk about. I talked about it in the members only live stream that we did this week, but I haven't talked about it here. So this is not the only dub this week. There was another one. Kavanaugh filed his defamation suit in a different court, not in the Beverly Hills court. And with that, Ethan's attorneys filed a notice of related case. The notice of related case states essentially, hey, new judge, this case right here, this defamation case is substantially related to this other Triller case that's going on in this other court. And it is in the interest of judicial economy that those cases be in the same court. They involve the same parties, the same lawyers, and essentially the same causes of action. And we know that because of how much the Triller case references Ryan Kavanaugh and statements made on the H3 podcast about Ryan Kavanaugh. So with that, Ethan's lawyers, which I thought was wise, Ethan's lawyers filed the notice of related case. The court ruled on that on the 13th. No, it was not on the 13th. That's when the notice went out. Where is the ruling? That was the notice of ruling. That's the ruling on the anti-Slapp. Let me find it real quick. There's the order. So the order was on January 12th. So the court ruled on the related cases on January 12th. The court ruled on the anti-Slapp on January, what was it? 12th. Same day. So same day, the court issued both rulings. And I'm going to pull that up real quick and show you what happened on the related cases. So on the related cases, the court that just issued that ruling said, hey, by the way, this motion has been filed and notice of related cases. And the court finds that the cases, this case, the Triller Ethan Klein case is the 225 case. And then the Triller or the Ryan Kavanaugh Ethan Klein case is the 868 case, are related within the meaning of the California Rules of Court, Rule 3.300A. 225 is the lead case. Why is it the lead case? Because it's the lowest case number. For good cause shown, said cases are assigned to Judge Helen Zirkin in Department 207 at Beverly Hills Courthouse for all purposes. The judges that heard the other case, the judge that ruled on the anti-Slapp. All future dates remaining on calendar is currently set, including final status conference. Any presently calendared motions in cases other than the lead case shall be continued to the newly assigned department and renoticed. So set new dates for the defamation case with Cav. This order is made without prejudice to the parties, making a motion to consolidate in the assigned department and stipulating to same, which means they can consolidate the two cases in the other department if they want, or in this department if they want. Counsel are reminded that related cases are still considered independent of each other, and any filings that will affect the related case need a document filed in each case. The cases aren't consolidated. They don't become one case. They are related, so they're heard in the same court so that the judge can schedule them on the same day and be like, hey, we've got all the same lawyers here anyway. Let's hear both cases today. Because what you can't do is forum shop. So when the cases are related, they need to be together. We saw this in the Toddy Westbrook, Clark Swanson case, where the California case, they're like, this is not the right form. The other cases are in Nevada. This should have been filed in Nevada. Everyone's in Nevada. The moving party's ordered to serve notice, the moving party being Ethan Klein. Guess what happened today? Yep. Seems that Cav doesn't love this ruling and filed a paper, a 170.6 paper on the judge in Beverly Hills, which is a challenge to the judge to try to remove the judge from the case. Papering a judge is a big move. It's likely to piss them off a lot. It's not always likely to succeed. And so now Kavanaugh has said that the judge in Beverly Hills should be removed from the case for cause. Not just a blanket paper, removed for cause. So let us take a look at this. Honorable Helen Zirkin, Department 207 Judge, this is a 170.6 peremptory challenge to the judge. I am a party to this action or special proceeding, the defamation lawsuit. The judicial officer named above, before whom the trial of or hearing in this case is pending, or to whom it's been assigned, and it's been assigned, is prejudiced against the party or the interest of the party so that the declarant cannot or believes that he or she cannot have a fair and impartial trial or hearing before the judicial officer. Declaration, I declare Ryan Kavanaugh signed under penalty of perjury on January 13th, 2022. I imagine that was yesterday. So the ruling was made. This, I imagine, was signed after the ruling was made. When was the Anti-Slapp ruling made? That's the notice of ruling. We're going back and forth between the two. The Anti-Slapp ruling was made January 12th at 4:17 p.m. January 12th at 4:17 p.m. So January 12th at 4:17 p.m., this ruling comes down, and the next day, there's a paper on the judge saying, you cannot hear this case. Send it back to the other courtroom. You can't be fair. You can't be fair. You are prejudiced against me because you granted the Anti-Slapp. So we'll see what happens on the 170.6. Could it be granted? Yes, it could be. Will it be granted for cause? Probably not. But I think they are within the time frame where they are allowed to file one paper, and the case will get shuffled and reassigned, unless the court finds that they've already made substantial rulings in the related cases, and then it can be denied. Sometimes it shuffles, sometimes it doesn't. So we will see what happens on that 170.6. It is timely, but the court ruled on the notice of related cases. But I don't know if ruling on the related cases is going to be enough because the case was then assigned to that judge for all purposes. And that is the proper time to paper the judge when the judge is assigned for all purposes. I don't think this is for cause. So yep. So we'll see. This might get yeeted out of the Honorable Helen Zirkin's courtroom because this judge has already ruled against Triller and might be annoyed with the lawyers, but it doesn't mean they can't be fair. Like, two things can be true at once. The judge could be like, that motion was dumb. But this judge really did go out of their way to, in my opinion, this judge went out of their way to give Triller grace, space, and opportunity to file more and consider the evidence. The judge set a 10-page limit and still considered the 800 pages of evidence that had no foundation and said, in like literally in the interest of justice, I'll consider this, but even considered it doesn't meet it. And the judge isn't wrong. The judge in this case is absolutely right. And Cav is just like, the judge doesn't like me. No, it has nothing to do with that. The judge ruled on nothing with regard to Kavanaugh's case. Nothing. Triller didn't meet its burden. That's what happened. I don't think Triller can meet its burden because I don't think Ethan did anything other than say shit that they don't like. Guess what? Unfortunately, not unfortunately. I shouldn't say unfortunately. It's not unfortunate. That's how free speech works. Free speech means people can say things that maybe you don't like. They can't say defamatory things. Nothing here is defamatory. I think they might be burning a really patient judge. Here's the thing that lawyers know and should know. Judges talk. Judges know each other. I don't know if this was a wise move, but we'll see. If they get reshuffled, maybe it's worth it. Maybe Kavanaugh's just like, I don't want to be in this judge's courtroom. And the lawyers are like, but a 170.6 is like a really bad look. Like a 170.6 is a bad look. And he's like, I don't give a fuck. Do it. And you are as a lawyer, your duty and your obligation is to your client. And if your client's like, fuck this judge, I want out of here. Not saying that that's what he said, but in my head, I can imagine it. But I want out of here. This judge won't listen to us. Then the lawyers are doing what's been asked by their client. Should end up in Judge Hess's courtroom, though he's retired. But if that came into Judge Hess's courtroom, he might have thrown the 800 pages off of the bench at the attorneys. And then he would have verbally eviscerated them to the point where they wanted to go back to their car and cried. So there are judges who are not nearly as patient as Judge Zirkin was. Additionally, if you are going, like, this is strategic brain. If you are going to be in trial on a business matter, the jury pool at the Beverly Hills courthouse can be very pro-business because a lot of the people that are being pulled into that jury are business owners, are people that live in the Beverly Hills area and Beverly Hills adjacent who are not going to immediately be like, oh, Cav has money, Cav bad. They're going to actually give consideration to Cav without discounting him just because he is in Hollywood or just because he's a public figure. He's going to, I think, get a little more grace from a Beverly Hills jury, where a downtown LA jury, and I can only imagine his lawyers practice in LA, and I can't give this kind of insight on other areas. I haven't worked there. I've worked in downtown LA. I know what the jury pool looks like in Beverly Hills. When you look at a downtown jury, you will get some business owners, but not as many. And you're going to get a lot of people who are going to look at him and be like, I'm sorry, you're bitching because somebody said what about you on the internet? We have actual problems. Where in Beverly Hills, you're going to get possibly business owners that are more empathetic to like a business being damaged by things that are said. So it's an odd move to me. But I don't, You don't know if Kavanaugh's lawyers sat down and said, if this goes to jury, Beverly Hills is better than downtown anyway. And he's like, I just want to be out from this judge. And it's like, but do you though? Yeah, I don't know. I don't think I don't understand the strategy behind the 170.6 here. And if I thought that the judge was being unfair, I would say I would paper that judge too. I totally see the reason. Valid strategy. I just don't see the strategy in a patient judge and a potentially very friendly jury pool and burning that. I don't see the strategy there. I don't. Maybe somebody else will. So me, it's going to be a short stream on one topic. Also me 2 hours later. Let's get to questions. With over 4,000 of you here, if you have not subscribed and you're watching, go ahead and do the likey, subscribey things. Your girl would just love to get to 200. And when we do, we are going to piss off more people on Twitter by going to like some kind of galaxy level hair. So, let's continue to piss off haters on Twitter. I'm teasing. That kind of stuff really doesn't bother me other than being like, really that though? That's where, okay. Okay, sure. Sure. All right. H3 collab when I am always careful when people are involved in litigation that I want to discuss to make sure that there are appropriate boundaries there. You all know how I feel about these lawsuits. I think these lawsuits are dumb. And I have gone on H3's show to talk about the lawsuits. I will talk about the facts of the lawsuits, but I also, when people use clips of my show, I never have a problem with that when they are used in a fair use way. So it's like, you can also use my content in a way. I always want to be careful because do I think that Cav would eventually get pissed at me and just be like, you shouldn't say shit? Possibly. I mean, we got a cease and desist from Clark Swanson because he's like, you talked about something that's evidence. And I'm like, sure did. Sure did. So that is the consideration that goes through my mind. But again, I talk about it. I'm always happy to offer comment on what I think. I thought from the beginning that this particular case was a loser. There's some legal issues I'm curious about in the other case. I don't know how far. I think the copyright case is fair use. Whether there's some issues the court will want to parse out, maybe, but that I see as a fair use case. And the defamation case, I don't see it. I've made my feelings on these lawsuits seen. When I think there's questions on both sides, I tell you, I think there's questions on both sides. I think some of these lawsuits are dumb. So, question, why would papering the judge change it from Beverly Hills to LA? It was originally filed in LA. It was not filed in Beverly Hills. So the original Kavanaugh defamation suit was filed. Let's see, who was it originally assigned to? Let me just pull up that case. It was filed in the Los Angeles court. It was filed in Santa Monica. My bad. Well, Santa Monica might have a beneficial jury pool too. I thought it was downtown in Brain, but I mean, Santa Monica might also have a beneficial jury pool. So, Fred, you can't step on the keyboard and get fur in my lips. Like, Fred, where I'm at. You're just moving the mic at this point. Filed in the Santa Monica courthouse. So it would go actually back to Santa Monica. I'm glad you asked so I could pull it back up. So the only reason this case moved from Santa Monica to Beverly Hills is because the judge that was presiding over the other Triller suit was in Beverly Hills. So it shifted to that judge's courthouse. Now, if they paper that judge, it'll go back to the courthouse where it was filed and reshuffle to another judge, and they might get a judge that is just not as friendly to them. Question, I don't know if I'm awesome. I just like to talk about stuff. So I'm sure there's definitely people who don't think I'm awesome. I love what I do. I love this community. I love talking about these cases, and I have no problem calling out bullshit when I see it. I also have no problem saying, well, this feels like bullshit, but actually there's like law there and we might not agree with the laws, but the law says this. And so even though it feels like fuckery, the law actually says that. I have no problem saying that either. Like the Colin and Cuthbert case. Do I think that the Cakes case is kind of stupid? Yes. Do I love these companies getting into it with each other on Twitter? Also, yes. But do I also acknowledge that intellectual property is a protectable right? It is. So you can't just blatantly rip people's shit off. Do I still think it's funny? Yep. Question: if anti-SLAPP succeeds for half the causes of action, does that mean the defendants could get half the money back? I don't know how the judge would parse it out, but that's definitely possible, and it wouldn't resolve the attorney's fees. I don't think would resolve till the end, but it's also possible that the court would say, "No, it's half and half. You're not getting lawyers' fees," and they can't do that. Who decides if the judge can't be fair? The judge. And there are some judges who are like, "Look, there was a criminal judge. I don't remember what courthouse it was. There was a criminal judge that I appeared in front of that had lost a family member in a DUI related crash. I mean, I have lost 2 friends in DUI related crashes. They were not drivers. They were hit by drunk drivers. I don't know why I felt the need to clarify that, but I did. And the judge would just close that on. I ended up doing a lot of vehicular homicide cases for a very dark period in my career, like a lot of them. And the this one particular judge would tell the defendants and the defense attorneys, "Look, I lost, XYZ family member in a, you know, DUI related car crash. I understand if you don't want me to hear this case. I have heard hundreds of these cases. I can be fair, but I want you to be aware. So if you can't be in this court, that is fair. I can recuse myself and you can go elsewhere." And some defendants said, "I appreciate that. I'm out." And some defendants said, "I'm not bothered. I'm here." There was a judge that I appeared in front of when I was doing civil matters that would disclose some of their holdings. They were hearing a lot of like the lemon law cases with Ford, and they would say, "Look, I have stock in Ford, but I can be fair in these cases. But if you don't want your case heard before me, it's fine. You can remove your case." So judges, it's part of their judicial ethics, and judges, it doesn't always seem like that because the stuff we see in the news is awful. But judges take their ethics very, very seriously. It's not worth your whole career to not disclose shit. They've like another case comes in. If this case goes out of Judge Zirkin's courtroom, it doesn't fucking matter to Judge Zirkin. Another one comes in the door the next day. Um, so let's see. Do you think Brittany will write a book or interview about her experience under Team Con based on her recent Instagram? I hope she does, and I hope she does both. And yes, I think she would need a interviewer who will allow her to speak her truth while also helping her frame that in a um a way that she feels good about. So, let's see. Um Question, do you think their lawyers can see some consequences for filing all these frivolous suits? Well, it depends. Um it, it's very hard for lawyers to have consequences for filing suits. We are seeing that in the limited context of some of the suits in the January 6th case, not the January 6th cases, the election law cases, where we have seen lawyers punished both in the courts and sanctioned for filing cases that had no evidentiary, support. But could Triller say, "Look, we believed we had evidentiary support. We disagree with the judge's ruling"? In these cases, probably. Is this as egregious as some other cases? No. Is it still bad? Yes. Do I think all of that's on the lawyers? No. Um, but when you get to things like misjoinder of multiple cases and failure to prosecute, you can get judges that are like, enough is enough. So it is so fact specific. At this point, I cannot make an assessment. It depends on a lot more. Um, Nicole asked, "What about the one Ethan said was thrown out for being improper?" The internet takedown is not a typically filed suit. It's more of an administrative action. So that administrative action's already been yeeted. Whether it will be brought back up again, we'll see. But that's more of an administrative action than like a traditional lawsuit because it's a website takedown. So, can Ethan sue for slander in regards to the articles about that Cav wrote about him? I didn't specifically look at the statements in that to evaluate whether I'm like, yes, there's a cause of action here. No, there's not a cause of action there. And that would border along giving legal advice. What I will say is that if there are statements in those articles that Ethan and his legal team feel are actionable, I think they are most likely to file those as counterclaims to Kavanaugh's defamation suit because it makes the most sense. They don't have to, they can just say, okay, you're suing me for defamation, but also fuck you. I'm suing you for these things too. and then they just become counterclaims in the same suit. We saw that in the Cardi B Tasha K suit that's in trial right now, and Cardi B won her motion to dismiss against Tasha K's counterclaims. So the only thing going to trial are Cardi B's alleged like defamation allegations. That's all that's going to trial because all of Tasha K's suits against Cardi B were dismissed. So yes, if they choose to do that, I think it will be a counterclaim. Question, how long does it take for legal fees and costs? Ethan mentioned it takes 2 years. Is that the average time? It depends on the case and the judge. And that's the other thing. That's the other thing. Thank you so much for asking this question. They've also papered the judge that still has to hear the litigation on attorney's fees. It's like, Your Honor, we think you suck. Don't piss off the judge that's determining these things, bro. But okay. So with that, it can take time. I don't know if it will take 2 years. It's a motion in this court. Do I think Triller will drag their feet? Maybe. They have a lot of litigation going on, but this judge has moved pretty quickly in this and has really, I think, been considered. I think this judge has been tremendously fair. So Jess says, told littlest 9-year-old, my littlest is 9 as well, how many subscribers Emily has. And she says she deserves more. I mean, I love the law nerds that we have. We're happy to have more numbers, but we're happy to be here. When I started on YouTube and hit 5,000 subs, I was like, this is it. We've made it. This is where our channel's going. So I'm constantly blown away that we're here. Like just constantly blown away that we're here. I just love being with y'all all the time, but thank you for that. I appreciate it. So I think I already answered this with legal fees. It can take time, but it might not take as much. It might not take 2 years. It doesn't have to be a separate lawsuit. It's a motion within this lawsuit with a judge that's now been paying for it. This is not a good look. Judges, it's not something I would do. Couldn't Triller make the case that fewer downloads of the app could then reduce the sponsors' advertisers, since that could be a metric? I don't know if they could because they didn't. And if they had that information, why wouldn't they have made that argument saying, but even then, it's not saying people they had a relationship with left. And it's not saying for every person who downloads the app, we project this much more money in advertiser revenue. They would have to show that the advertisers are leaving. So it would be very hard for them. And if they had that information, I don't know where their legal team didn't share that. So question, do judges have help with writing these statements or are they on their own? It depends on the court and the judge. Most judges have research attorneys that do this. This is what I did as a job as a research attorney. I wrote rulings like that and submitted them to my judge, and my judge would tweak some of the language and sometimes take parts out or ask me to put parts in. But I would write bench rulings and rulings like this for my judge as a research attorney. Well, for my judges as a research attorney. I worked a lot in that job. Like I worked all the time. It was very busy. Trisha Lynn, hello. Which suits are still active? The federal copyright case and the defamation case between CavCav and H3. So those are the two. What are the chances of appeal by Triller? I think that even if they did appeal, they would get skunked. I don't know if they want to waste the money on it or if they want to just focus on the other stuff. So I don't know if they would. This judge gave a very thorough ruling and they're not going to win on appeal. It would really just be a waste of money. It doesn't mean they won't. Whim, anyone else have to resub because of YouTube? YouTube regularly helps itself to like 400, 500, 600 subscribers at a time and are like, these people are yeeted. And I look at my subscriber numbers. I'm like, what in the purge is this? And they will just go through and like remove subscribers. It's a strange phenomenon that happens on YouTube. So when I set the chat to subscribers, only half of it, so people can be like, oh, how did I get unsubscribed? So I am way behind on the chat. So why does Ethan have to sue for legal fees? Why doesn't CavCav have to pay them right away? They are entitled to legal fees. They have to make the motions to get them and the court has to rule on them. So Fred is all over the place. Always. Fred's on the keyboard. Fred's on the soundboard. Fred is all over the place. Question, what lip color are you wearing? Thank you. I am wearing Gerard Cosmetics Bel Air under a lip oil. And this is Dior Lip Glow Oil in Cherry. So it is and Welcome to my cat hair life. So that I love this lip oil. It can get a little sticky when I talk, but I don't have any of my other glosses in my drawer. So Bel Air and Cherry. All right. Question: Is there any way Cav can win the two other suits? Based on what I've seen now, I don't. I see the copyright suit as fair use. I don't know how it wouldn't be, but that doesn't mean there's not something I could miss. I want to go back through and look at some of their arguments, but I see it as a fair use case. I just don't see how they would win that. And on the defamation, I don't see anything that was defamatory. All the statements are a business partner said this in an article. That's true. So Kevin Hart must be so relieved. I don't know if Kevin Hart knows or gives a shit, but if Kevin Hart's name and likeness was being used to advertise the Triller app saying Kevin Hart's here, Kevin Hart could have sued and said, no, you can't use my name and likeness. Who did we do a name and likeness case with? We did a name and likeness case with somebody and Robin Hood. Was it Ice Cube? It wasn't, it was last year, but we did a name and likeness case. It can't happen. So what else? Question: Is the flavored whiskey sweet or just flavored? This one is sweet. This one is peanut butter cup. This is a Tennessee Legend peanut butter cup that has a peanut butter flavor, but then chocolate notes to it. I also love the Old Smoky peanut butter whiskey that's peanut butter with like vanilla notes to it. I also like the Screwball just peanut butter whiskey, but yes, they are a bit sweet. I like a sweet whiskey, but they don't give me headaches, which is why I love them. Will Ethan's legal fees be public? I would love to know what Cav has to pay. I hate this answer. It just doesn't roll off the tongue. It depends. The motions will be public, but they can also settle. They can settle that aspect outside of court. Do I think Triller's inclined to settle anything? Not based on what I've seen. It doesn't mean that Triller's not going to be like, we lost, can we just settle this? They could settle that out of court. They could not. And we saw that in the Keem Romeo Lacoste suit, where Keem settled for less legal fees than they were entitled to because they also wanted the million sub play button. So stuff can happen. So question on the cancer patient and the judge is like, if I could give you jail time. I have not seen that, but I've also been like kind of in the weeds of work this week because it was a week of no streaming because I was doing other like deep dive work. So I have not seen that. Question: Is it defamation if the subject is an honest opinion based on facts, like this company steals art from small artists, has cheap materials, and is bad for the environment, so I don't support them? That's a very specific statement of facts, and I would need more surrounding facts because that seems to be maybe asking for a legal opinion. But that is a very fact-specific question. So it unfortunately depends. When we went through tonight's case, we went through the context that's considered. Not all opinion is protected, but facts that are true are protected. So I would look at the Chalene Johnson suits and my commentary on them to see where we talk about what is fact and how you prove that it's fact, because it has to be a provable fact. Hopefully that helps. Question: What are your thoughts on the judge who yelled at an old man with cancer for not being able to take care of his yard? I'm so angry. Samantha, again, as I answered about, I haven't seen it. I will pull it up, and if it's on, so I imagine it's on social. You guys can tag me in it. I'm sure I've been sent it in my DM somewhere, but I'll look at it for Tuesday. Question: How's George? I thought in the chat the other day that he was hurt. He had a hurt paw. He is on antibiotics. The vet cleaned up his paw and he's been running around here today like nothing is wrong. So he is doing well. He's all cleaned up. He's a kitten. So he's good. But yes, he did hurt his paw. I think brother hurt his paw by accident. Question: If a judge set a page limit, is it violated by like 800? Does the judge still need to read every page? No. The judge could have said, I'm not considering this. But the judge didn't say that. The judge said this violated my page limit, but even considering this, it doesn't save you. The judge did not have to, but they did. This judge, I think, gave a heaping football field full of grace. Fatal exception. This is totally unrelated. Perfect. But I was wondering if you've heard of or kept up on the is I'm not going to be able to pronounce Djokovic situation in Australia. Curious to hear your thoughts. Tennis. I have not been following it. I'm sorry. I'm sorry. I'm sorry. Sorry. I have not been keeping up on it. Will I? Maybe, but I'm prepping a podcast for next week on the Prince Andrew stuff. And I've been kind of deep diving into the world of critical thought academic research. So, nope, haven't seen it. I am sorry. Let's see. Question Spockter. I don't know who that is. I'll have to go look. Spockter dropped a video today stating he believed Creepshow Art's video was made with a legal team. What's your opinion on this claim? I'm not familiar with the claim. I have not watched Creepshow's entire video. That would take a lot of time. It was a fairly long video. I've seen commentary videos on it, but if I have time, I will watch it and let you guys know if I have any thoughts. It's always possible that people make things with a legal team. It's possible that they don't. It's possible that people say they do and don't. So I have no opinion at this point. So let's see. Let's see. Question. I am ex-friends with a small YouTuber, afraid to say who. Let's not name names in the chat. It's perfectly fine. Who is infamous for slaps. We were working on a project and they used to manipulate me. What can I do if they come after you? If you're in a state that has an anti-slap law, you file an anti-slap. Otherwise, you fight it. Because if the case is if it's a lawsuit, it's different. Cease and desist are different. I think the first step is consult with a lawyer in your area who's familiar with the online space, and anti-slaps work for this reason. Do Ethan and Cav actually show up for the hearings? Generally not. Just the lawyers. I'd love to be a fly on the wall while they were in the same room. I would too, but generally not. And in this one, Kavanaugh's not a participant. These hearings would generally just be the lawyers. Though clients can go, they generally don't because they make more money doing the other things they do. Oprah should interview Britney. Facts. Just facts. Yes, I heard you, Fred. Bling is the new black. Hello. Howdy from Dallas. Howdy to you. Question. What about the fourth lawsuit that Ethan said? I think I talked about that earlier. That was the takedown of the website. So more of an administrative action, but yes. They said dismissed. His lawyers would have gotten notice. I hadn't even pulled it or looked for it. Fred's just going to be a flop. He's just like, I flops on moms. He's the biggest cat. Question, have you seen the fifth? Okay, we talked about that one. It was thrown out. It wasn't thrown out. It wasn't thrown out with this anti-slap, not to be picky on words. It was thrown out on its own accord, probably because it was filed wrong, which means it could be resumed. So let's see. I'm going to try. I am so behind on the questions. Okay. Question. Ethan said the same judge will review the copyright case, is asking the judge to be removed to prevent that. The copyright case is in federal court. So the copyright case stays in federal court where it is. The judge from the Triller case, this one in California, is the judge on the defamation case. The paper can prevent that, but the federal case is staying in federal court. It's not been removed from federal court. I'm trying to, Fred. Anika says, my aunt is a research attorney. She worked for the same judge for almost a decade and loves her job doing what she does. I think if I hadn't gone to the DA's office, I would have enjoyed staying as a research attorney. The thing is, I very much like to talk. I enjoyed being in court with juries and stuff. So I don't know how long, but I really did enjoy that work. Where are you going? I really did enjoy that work doing it. It was fascinating. I loved the judges I worked for. I really did. I thought they were fantastic judges and they were really fun humans. So I like it. What else? Fred is now just like laying on my lap. Oh, this is the longest. You are such a big cat. You're only a year old. Why are you so big? We're not shaming Fred. We love Fred. Beth said, such great delivery of content. Thank you. Fun and wonderful law nerd chats. Your channel is truly my favorite. Thank you. Love your lipstick color too. Appreciate it. I love our chats too. That is a huge thank you to our mods who knew we were off this week and rode anyway. And that is a huge appreciation to the mods who help keep the chat um the kind and considered place that it is, because having discussion doesn't always mean that we agree, but it does mean that we can be kind, and that is really important. So I appreciate it. What else? Question. So, like, is Kavanaugh really just self-destructing here? Well, that was all Triller. So they have other attorneys on the defamation suit that are not these attorneys from this suit. And the Triller in-house counsel won't be working on Kavanaugh's personal suit. It sounds like he's just making the possible repercussions worse and worse. He seems big mad. So he seems big mad. What else? I'm trying to get to question. Fred is now just like messing with my feet. Sure, Fred. I am so far behind in the chat. Apologies, chat. This is for Brittany's leave fund. I saw that on Twitter. It's like, why doesn't Brittany just have a leave? Like, get the girl some leave. But I definitely think now that she's in charge of her own socials, don't you? Because she just has been sharing on socials, and I love that she finally can. It's interesting to see. Will I read Jamie Lynn's book? I don't know. Maybe. It's like I'm torn. I don't necessarily want to give Jamie Lynn money. I will probably watch other people's reviews of it and decide if I need to see it for myself, because it's not really my realm of content. There's so much else that I'm reading with the stuff I keep up on that I wouldn't make content out of it. And I don't know if I'd want to give her money for it. Oh, you want to play catch? Okay. Should we make you go back so the law nerds can just watch you and your wonderful okay, go on. So he likes to play catch. He loves to play catch. So I don't know if I'll read her book. Question, do you think Ethan could sue Cav for defamation? I think I addressed that earlier. If they feel that there are actionable statements in the articles he published, they can probably, and they probably will. If they feel there are actionable statements, I imagine that they will file a cross-claim or a counterclaim, as it is sometimes called, in the defamation suit. Feel like paying people for information is illegal. It's not, though. And it happens. Like, you've seen the wanted posters, like, hey, information leading to an arrest in this case for this much money. It's not unheard of. My very big ice cube is now Fred, stop trying to play with my glass. Is now a very small ice cube. I can't reach it over there and throw it for you, buddy. You got to bring it back to me. He's just like, no, we want to play catch. So, question, if Jamie Lynn's book has false statements, could Brit sue? If they're defamatory, it doesn't matter where the defamation is published. Defamation in a book is still defamation. The remedies are normally different, but defamation in a book is still defamation. Question, can we get whiskey or spirits recommendations list sometimes, maybe on Patreon? Sure. If you guys want to know, I can. I mean, I can just tell you what I like. So, yes. What else? I'm going to do 2 more questions. I'm sure there were some super chats from earlier that I missed, so I'm going to try to get to those real quick. And then I'm going to say goodnight. Oh my God, it's been 2 hours and 22 minutes. Oh, me, one topic, it'll go quick. Also me. Let's talk forever. Oh, y'all are so patient with me. Thank you. And thank you to the mods for an extra ride and just hanging in there. Haley McInnes, thank you. How I've missed lives lately. Let's ride Law Nerds. From Gay Void, Foot Soldier turned Law Nerd here. Thank you for the super chat. Peggy Cole, thank you for the super sticker. Lynn Monk Treadway, I needed an Emily fix. Well, thank you. I mean, if you want to go follow me on the Instagrams or the YouTubes. Well, this is the YouTubes to like and subscribe, do the thingies, the likey, subscribey things. But also I'm on the Twitters and the Instagrams. And when I'm not on the YouTubes, I'm over there. I'm trying to be more active on the community tab here, so things are in one places. One place is one place. Whiskey. Spork, thank you for the super chat. Janice Wingfield, someone said Lawnard Cella. Ella, eh, eh. No, we're not having Lawnard Cello. Whatever we have Lawnard, we'll call it Lawnard Con or something. We'll have to do a con, like a VidCon or a Comic Con or a, whatever. We'll just do a con. We'll do a Lawnard Con. I, at some point, would love to do like Deep Abiding Secret, or would love for someone to do like a commentary con. Bring together, or like LawTube Con. Bring together everybody. Let's have panels and discussions and talk about things, take questions. I think it would be epic, but we'll see. Maybe as the world gets back to doing things in person, I think it would be so much fun to do like a commentary con. But Lawnard Con would be great. Lawnard Con would not be like TanaCon because I'm a lawyer. Also, we would do a much smaller event than that. DramaCon. Oh, you guys are like CavCavCon. Look, if that goes to trial, we'll just line up outside the courtroom to go watch it. But again, a lot of things don't go to trial. Lauren said, just because you're the ish. Thank you. And I appreciate you giving us an update on your off week. P.S. Your hair looks amazing. Well, thank you for the hair. Look, I went live because A, I really wanted to talk about this. B, next week's already going to be busy, and this needed its own moment. And also it's top of mind. And I wanted to answer all of the questions I was seeing about it because I know there is some confusion. Janice, thank you for the super chat saying Slapchella. Tonight was Slapchella for sure. It's hyperbole. We're not trademarking it Coachella. Don't get mad. You're the name of a city too. Samantha said, question, what are your thoughts on okay, we got to those. So I am now caught up and I will go look at what that judge was. I don't know. I think, and most of the judges I appeared, not all of them, most of the judges I appeared before were compassionate humans that were interested in trying to do what was right. I think there are lawyers across the board who, when they are in the job for too long, can lose a bit of their compassion and humanity. It can happen. It's why I think people need therapy because it can be a very hard job when day after day after day you have people that either lie to you, that don't want to be there, that aren't doing what they're supposed to, that are horrible to each other. It can be a very difficult profession. And sometimes people need to step away and say, I can't do this anymore. Or I need a break so that I can kind of regain my human side. So we'll see. I'll take a look at that, what's going on with that judge, but I can't. Judges are generally elected. And if judges are elected, they can also be beaten. The thing is with most judges don't have people run against them. So even though they're elected, someone has to run against them. So part of unseating most judges is finding someone willing to run against them. Do you guys want to know T? Okay, and then we're going to go. This is the end of the stream. No one's going to see this. It's fine. We're all friends here. Here's the T. And this is particularly true when you're in smaller communities, but this happens even in Los Angeles and other large communities. When you become a member of the bench, you become a member of the bench, and you are part of a new career where you have a boss that's a site judge, and the boss is kind of in charge of your life, and the boss can put you in a shit assignment or put you in a great assignment. You can be in an assignment where you can rise in the ranks as a judge, or in an assignment where your career is stifled. Being a judge has a very political, like internal office politics element to it, not a political, national politics side of it. It has a very, well, that too, but it has a very internal political structure. And then if judges have aspirations to go to the federal bench or to move through the federal ranks to become federal appellate judges and to move up to federal or state Supreme Court, that is also by way of working together with other judges. It is generally significantly frowned upon to run against a sitting judge. So that means if you run against a sitting judge, you walk into a new kind of wing of your career and everybody's looking at you like, who do you think you are? We don't do that. We run for open seats. We do not run against sitting judges. Like, this is not done. So you're already putting yourself at a disadvantage to unseat a judge. It doesn't mean people don't do it. A DA who I very much like and worked with ran against a judge that I used to work for. Well, not for, I was not their research attorney, but a judge whose courtroom I worked in. That's the appropriate word. And was like, you know what? I'm done. You shouldn't be on the bench anymore. I'm coming for you. I'm going to run against your seat. Good luck. And she unseated him and he was done. So it is difficult to find attorneys with the experience willing to run against sitting judges. And even if it's what the public wants, it can put that person at a significant disadvantage career-wise, which is wild, I know, but it is why you don't see people traditionally running against sitting judges. And you can't just normally yoink judges, they can be unseated. So if a judge is significantly unpopular, they might also be unpopular with their colleagues, but it would take some wrangling to find out if that was the case and find a candidate to run against them and then support them financially to run against a judge. It can happen, but it is a precarious and a considered thing that would have to happen to find the right candidate to run against somebody. Not everyone has the fortitude to say, I don't care if y'all don't like me. This is the right thing to do. I'm running against that judge. I don't care. I'm here now, bitches. What? What? Deal with me. Deal with me. Not everyone has that gut. So Tiffany said judges here are appointed, not elected. They are reelected. And in some areas, obviously, in some areas that's true. That can happen in LA as well, where you are appointed and then rerun. But when there are open seats, people can run initially and are not appointed. So do judges have terms? Yes and no. It depends on the seat. So some Supreme Court, well, the Supreme Court doesn't. Some appellate judges don't, but generally state level judges do have terms and rerun. They generally rerun unopposed. So people go to the ballots and are just like, yes. And they get elected. So that's how that works. So as we're talking about the way things work, that is the way things work. So if there is a judge in your locality, talk to the local attorneys about why no one runs against the judge and try to find out what's going on, because you can unseat them. If a judge is unseated, can they run again the next cycle to try to get their seat back? They can, or they could run for an open seat. They could regain their position as judge through a number of different ways. Sometimes that is expensive. Sometimes they're like, I've done this enough, I'm retired. And they take their generous retirement depending on where they work and they go. So Alex said it's a Game of Thrones situation. It can be. And it can be very, very interesting. So there are a lot of factors that go into it, but I think if you understand the factors that go into it, you can ask the right questions in how this works in your area. If there's a judge in your area that you're seeing fuckery from, look at how judges are elected or appointed in your county, in your community, in your parish, in your area, and or in your circuit, because some, like in Texas, they ride circuits. So you can find that information on the internet, and you can ask lawyers. If you know lawyers in your area, start asking them those questions. Not all lawyers might know, but I think all of them should know somewhat. So that is a little inside baseball on how that works and how the judgy things work. So Katya, yes, tell Cersei it was me. Accurate. All right, y'all. I am going to go play. Oh, it's 9:30. It's time to go. I am going to go play some card games with my kids and maybe get snowed in this weekend. Maybe not. I'll keep you posted. Right now, my grass is green. It's cold outside, but it's green. But we're supposed to be getting snow again here in Middle Tennessee, so I am excited for it. We'll see what happens this weekend. And I'm going to answer one last question. Sarah, have you ever wanted to be a judge? I never thought that I wanted to be a judge. I still don't want to be a judge. I liked the side of the law that I did. I liked being an advocate for justice. I liked doing that very much. And in being a judge, you're not on a side. I like breaking down the cases now. I think as a judge, I have a snarky face. And I think people would piss me off and I would maybe struggle to get over that sometimes, which isn't fair. So I didn't really consider that I'd want to be a judge. I mean, and I'm not going to switch jobs for like the pay. It's just, I like doing this the best. I think this is really what I was meant to be doing. It's the thing that makes me the happiest. And I get to be snarky and say the fuck words. And I don't have to look these attorneys in the face and be like, I'm sorry, counsel, are you for real right now? Cause are you fucking kidding me? Cause that's just, you can't do that. That is not adequate judicial temperament. So no, it was not on my like to-dos. Do I miss being in a courtroom? Generally not. Thing I miss the most about being a DA is going to lunch with my coworkers. And that is the absolute truth. I adored a lot of the people I worked with. I liked the judges I worked with. I liked the lawyers I worked with for the most part. I liked the defense attorneys I worked with for the most part. There are people that I miss seeing on the day-to-day, but I get to connect with them through doing this work too. So do I miss the stress of it? No. Do I miss the waking up in the middle of the night in a cold sweat being like, oh my God, I have to say this in my closing argument? Nope. That I do not miss. Thank you for the super sticker, Ashley. And you know what? If I was still doing that, I wouldn't know all of you. I would not be on the internet. I would not have a social media presence. I would not be doing this. I love doing this. I love breaking down the law for y'all. And if there are people who are passionate about making change that hear my content are like, oh, you can unseat a judge and make that change in their local community to better their community. I think that's having more impact than doing things otherwise. So I hope that this is an impactful position. And I like this so much. And I like y'all. So it is time for me to say goodnight. That I've said goodbye 1,700 times. I think next week we are going to have to bring back the court of public opinion. We've had some very long streams with lots of information and we haven't gotten to do it. So this just needed to be. We needed to talk about the Trillery H3-ness of it all. And I appreciate you. Thank you for being here till the end. If you are in the replay crew, I didn't even say replay crew, we love you. Sorry, replay crew, we love you. You're welcome to put in the comments, I made it. I know the secrets. And just say, I know the secrets. Because the people who didn't make it to the end don't know the secrets. Y'all now know the secrets. We talked about the secrets and everyone else will be like, what are they talking about in the comments? Well, you got to go to the end to know. And if you know, you know. But if you don't know what you don't know, it's a lot. Yes, that is a Peter Mon shout out. And with that, it is time to say goodnight. A huge thank you to the mods. Thank you. And good night. Have a wonderful weekend. Stay safe. Be good to yourselves. Stay hydrated. May the odds be ever in your favor. Thanks for being a law nerd. Like, subscribe, do the things. Bye. Connect with me everywhere. I'm at the Emily D. Baker. If you guys want to join the text, just text Emily.com. If you want to join the channel, lawnerdsunite.com. Happy to have you. Support what we do here on the YouTube.